God save the Commonwealth and this honorable court. Please be seated.
Good morning, everyone.
Good morning, Your Honor.
I'd like to welcome you all to the second day of our fall session here in our magnificent courtroom in Pittsburgh. I would point out that the Pennsylvania Supreme Court is the oldest appellate court in North America, and our roots date back to William Penn's Provincial Court of 1684. Our Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722, and in May we celebrated our 300th anniversary in Philadelphia with a special session in Old City Hall, followed by a two-day symposium at the National Convention Center. We on the bench are very proud of our rich history. On a sad note, as you all know, our beloved colleague, Chief Justice Max Baer, passed away on October 1st. This is a tremendous loss for our court and for all of our state judiciary. Pennsylvania has lost a jurist who served the court and the citizens of the Commonwealth with distinction. Chief Justice Baer was an influential and intellectual justice whose unwavering focus was on administering fair and balanced justice. He was a tireless champion for children, devoted to protecting and providing for our youngest and most vulnerable citizens. His distinguished service and commitment to justice and fairness spanned his decades on the bench. First, as a family court judge in Allegheny County, and then as the administrative judge of our family court here, and then as a Supreme Court justice, and then Chief Justice. On behalf of our court, we offer our deepest condolences to Beth Baer, the rest of Chief Justice Baer's family, friends, and staff. Anyone who has appeared before our court or observed our argument sessions knows that Chief Justice Baer was collegial to everyone in the courtroom. He was compassionate toward the litigants and their positions. Most of all, he was committed to deciding cases in a thoughtful, fair, and impartial manner. As we continue to mourn his passing, we know that the best way for this court to honor his memory is to continue to serve the people of this Commonwealth with dedication and fidelity to the law. Before the court crier calls our first case, I would like to briefly remind counsel of a few matters of protocol. Please approach the podium when your case is called. I will then give a brief summary of your case, which you can correct if I have misstated anything. Please begin by introducing yourself and your co-counsel and identifying the party you represent. As you know, if you've appeared before us, the justices are familiar with your cases, so we ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel may choose to rely on their briefs for particular issues if you so desire. In cases where there are multiple parties represented by separate counsel, counsel should not repeat the same arguments as prior counsel. Our previous Chief Justices have referred to this as the no piling on rule. Please do not interrupt the justices when they are asking you a question, even though they will interrupt you. We will interrupt you. A justice's question is not meant to trip you up. Rather, it's an indication that there are particular issues that we want to explore further. Finally, our court does not permit rebuttal argument. We have no set time limit for your argument. I will advise counsel when we have heard enough, and at that time, I would ask that you conclude your argument. I point out that our colleague Justice Brobson is not participating in the first two cases. Mr. Minner, would you call the first case?
Allegheny Reproductive Health Center et al. Appellants versus Department of Human Services. Jacob Corbett and Brian Cutler
In 1982, the General Assembly enacted the Abortion Control Act, which banned the use of Medicaid funds for abortions, except where necessary to prevent the death of the mother or in cases of rape or incest. In our 1985 decision of Fisher versus Department of Public Welfare, this court unanimously upheld the constitutionality of the Act's coverage ban. In this appeal, we consider similar challenges to the Act's abortion coverage ban. As well, we address threshold questions of whether the abortion providers bringing this challenge had standing to do so, and whether individual Senate and House legislators had the right to intervene. Please proceed.
Good morning, Your Honor. Susan Fritchie of the Women's Law Project, appearing on behalf of appellants, along with my co-counsel David Cohen and Christine Castro, who is also with us on the briefs. Before I begin, I want to express our deepest condolences for the terrible loss that the court has suffered with the loss of Chief Justice Behr.
Thank you.
With the court's permission, I would like to begin by addressing appellants' constitutional claims, and Professor Cohen will then present the third-party standing and legislative intervention issues. May it please the court. Today we ask the court to overrule the Fisher decision, to affirm that the Pennsylvania Constitution protects the right of reproductive autonomy as a fundamental right, and to strike down the Medicaid abortion coverage ban. The coverage ban is a prohibited sex-based classification that perpetuates gender stereotypes and severely harms women in violation of the Equal Rights Amendment. And the coverage ban violates the equal protection provisions of the Pennsylvania Constitution as well, by discriminating against the exercise of fundamental reproductive autonomy rights. Now, the Fisher court rejected those same two constitutional claims because it chose to march in lockstep with federal constitutional analysis of the very disparate federal equal protection clause. The Pennsylvania Constitution is more than a row of shadows. This court has the authority to interpret it independently and more expansively than the federal Constitution, and there are some very compelling reasons to do that here. So first, the Edmunds framework didn't exist in 1985 when Fisher was decided. The Medicaid coverage ban was evaluated one time in one case, and because this case involves a constitutional question of enormous public importance, it is important to reevaluate and take a fresh look at whether the Pennsylvania Constitution is more protective of reproductive rights than the federal Constitution, using those Edmunds factors.
Counsel, if I may, you indicated in your opening that this perpetuates gender stereotypes. Share with us how that perpetuates gender stereotypes when only females can give birth.
So, Your Honor, the mistake that the Fisher court made, which is really at the heart of why that decision is so wrong, is that it looked at whether a unique physical characteristic was in play. And the minute it detected that it was, it stopped the analysis. It didn't inquire into whether that unique physical characteristic was in fact a source of much of sex discrimination. And women's capacity to reproduce, women's ability to become pregnant, historically has been at the heart of sex discrimination. It underlies, a whole history of disadvantageous treatment. It underlies myths about women's roles, about what their proper place in the world is, myths about women's fragility, about our ability to think, kept us off of juries, denied us education, locked us out of entire professions.
But this is very specific in discrete legal issue. Your argument was that the abortion issue is, or the Fisher case is extending or perpetuating gender stereotypes. I want to key in on that. Based upon your briefing, once again, share with me. I understand the history of gender discrimination, but we're here for a discrete legal issue. Share with me how that is so.
So, Your Honor, it's denying women access to needed medical care on the basis of a sex-linked condition. And it makes an assumption implicitly that the role of women is to give birth and be mothers.
Ms. Fritchie?
Yes.
I guess my concern here is that this is not really a gender issue as much as an issue of indigency, who can and cannot afford an abortion. And being female, that is a protected class, but this case is seeming to me to be more focused on indigent women, and I wondered if you could expand on that.
Yes, Your Honor, we are not asking this court at this time to recognize that indigency or wealth would be a protected classification. This is a purely sex-based classification, and we know that for 3 different reasons. So first of all, it's facial sex discrimination. The statute says pregnant women. The category in the statute is explicitly facially sex-based, and it carves out from otherwise comprehensive medical care an extremely common medical need of women. 1 in 4 will need an abortion, and it's linked to female reproductive capacity. There is simply no comparable medical care that men need that Medicaid carves out. There is no...
May I follow up on? Are there any such procedures? Are there any procedures for men that are medically necessary that are not covered?
No, Your Honor. We have not been able to find any comparable medical care that men need that Medicaid doesn't cover, that's in any way comparable.
And no medically necessary procedures for either gender, for any groups, anybody other than abortion that aren't covered?
There are medical procedures that are not covered, Your Honor, but not sex-based ones, and none that are in any way comparable. We're bound by the record. The record doesn't, and all the briefing that happened in this case, no one has pointed out another comparable medical care that men are deprived of. And we have not been able to find any such case.
And counsel, Justice Donahue, you're here on preliminary objections. So
That's right, Your Honor.
Assume that the facts as set forth in your petition are correct.
Exactly, Your Honor. And in all the briefing, no one has come forward with any comparable. So what we're left with is a Medicaid scheme that covers comprehensively people's medical needs except for this extremely important medical need that many women need, and that has such a close connection to women's capacity to function equally in society and to direct their own lives. Fisher just ignored that entirely. It ignored the fact that being deprived of access to abortion, we now have empirical evidence about what that does to people that we didn't have in 1985, which is another reason to take a fresh look.
It's a big challenge to ask our court to overrule a case that was decided unanimously by this court in 1985. And as you know, we are concerned always about the doctrine of stare decisis, and I'd like you to just address that, if you will.
Of course, Your Honor. DHS does not even attempt to defend Fisher's reasoning and relies solely on stare decisis, so it is indeed an issue in this case. But stare decisis is not a vehicle for perpetuating error. This court has not hesitated to overrule prior precedent when constitutional rights are on the line. You've done it with education rights, search and seizure, voting rights. Very recently in McLinko, privacy rights, which is so important because privacy is a linchpin of our argument under the equal protection provisions. The jurisprudential considerations underlying stare decisis are weaker where the original decision was poorly reasoned, as Fisher surely was, where there are no reliance interests at stake, which is the case here, and where the ruling's a constitutional ruling on a matter of broad public interest and import that has only been passed upon on a single occasion. The court has not hesitated to revisit constitutional questions under those circumstances.
Is Edmonds itself an additional justification for reviewing Fisher, or is that not an additional reason?
It absolutely is, Your Honor. And when you look through those 4 factors in the Edmonds framework, you see that they weigh in favor of departing from the federal body of law related to Medicaid coverage of abortion.
What's your understanding of what the government's interest is here, and what level of scrutiny should we apply to that interest?
So under the ERA, starting there, the words of the ERA are unqualified. They say equality of rights under the law shall not be denied or abridged in the Commonwealth of Pennsylvania because of the sex of the individual. So the standard of review for sex-based classifications under that provision would be extremely high, at least strict scrutiny. Under the Equal Protection Clause, we are dealing with a fundamental right, the fundamental right of reproductive autonomy, which flows logically and necessarily from Article 1, Section 1.
Excuse me, we're not dealing with a fundamental right with regard to reproductive rights. This is a funding case. We're dealing with the right for your company to be reimbursed for this procedure. It's a funding case.
Your Honor, what we are asking for is we're not claiming that every abortion is entitled to be paid for by the government. This is a case of equal protection and equality rights. And so what we're saying is Pennsylvania does not have to have a medical assistance program, but if it chooses to have one, it cannot have one in a way that perpetuates gender inequality and that entrenches these traditional gender roles that have historically and continue to harm women and prevent our equal participation.
Counsel, share with me, we're presupposing the constitutional challenges, but one of the questions we've accepted is the standing issue. Share with me how the providers have standing to assert a constitutional right of an individual woman.
Your Honor, with your permission, the standing and intervention issues will be addressed in great detail by my co-counsel, Professor Cohen. Not to dodge your question, Your Honor.
Ms. Rishi, could we go back to your answer to Justice Mundy's question regarding funding versus the right to an abortion? We have never said here in Pennsylvania that any right to any analysis of funding involves a fundamental right, or was a fundamental right. Could you just clarify that for me? You presuppose it's a fundamental right, and I just want to examine that since we're not talking here about the right to an abortion. We're talking, as Justice Mundy pointed out, about funding for an abortion. So if you could just focus on that fundamental right issue, I'd appreciate it.
The fundamental right nature of reproductive autonomy comes into play in the equal protection analysis because that's what tells you what level of scrutiny you give. When you look at Article 1, Section 1, you start with the text. The text says, all men and women are born equally free and independent with inherent and indefeasible rights, including life and liberty. and those words have a meaning. Reproductive autonomy, the ability to determine whether or not one will bear a child, is an inherent aspect of life and liberty under Article 1, Section 1. And this court's case law has all but said so already. You have the Nixon case talking about the right to privacy, Ladd versus Real Estate Commission, the right to privacy, the right to marry, the right to procreate, identified as fundamental rights under Article 1, Section 1.
Now you're going into some substantive due process cases, and I assume you would maintain that that the analysis, well, I shouldn't assume, let me withdraw that. Is there a different analysis, because I took it from your briefing that there is, that applies to an ERA case or an equal protection case than to a substantive due process case?
So, yes, Your Honor, the two claims that we have brought involve equality concepts, but as this court analyzes the equal protection provisions, a different level of scrutiny will be applied depending on the nature of the right at issue. And
You want an absolutist approach. That's why you don't want really to go on those ladders of scrutiny. You don't want to start down the Caroline Products footnote, et cetera, et cetera.
Your Honor, there are two different claims, two complementary claims that reach the same conclusion. The ERA has pretty absolute language. And as we said in our brief, we're not saying that there will never, ever be a unique physical characteristic that could not undergird differential treatment between men and women. But it's not this. It is not a matter that is so life-determining, that is so tied to a history of disparate, disadvantageous treatment of women. It is not the Medicaid coverage ban. And the Medicaid coverage ban, I must say, has taken an extraordinarily harsh toll on particularly women of color, Black and Latina women, who are precisely the groups who have endured perhaps the most brutal history of systematic and legally sanctioned.
On that, because I'm glad you brought that up, because when you, and I saw that in the briefing, when you head in that direction, of course, you're pinging on certain equal protection case law that's out there in the federal context. And I'm wondering how that complicates or affects our analysis, because your ERA arguments here and your equal protection arguments here are gender-based, as we've been hearing. But references to race seem to take us onto another track. So is this a gender case, or do you want to add sort of a race aspect to it? So, because I find that a bit confusing, because at least it's going to add another paradigm of analysis. Do you follow what I'm saying?
Absolutely, Your Honor. And we did not bring a race-based claim against the Medicaid coverage ban. But where the awareness of that racial disparity comes into play is in the Edmonds analysis of policy considerations. Pennsylvania has got a particularly awful maternal mortality rate that has gotten worse and worse and worse. And that's set forth in the expert affidavits attached to our petition for review. Under the Edmonds policy framework, we look at particular local and state facts that inform the analysis. And one of the facts that can and should inform this court's Edmonds analysis of the policy implications of the Medicaid coverage ban is that it is crushing communities of color who have historically endured legally sanctioned reproductive coercion and who are currently enduring terrible maternal mortality much, much more heavily than white women.
I'm sorry, are you done?
Yes.
Let me see. I have what might sound like a technical question, but it's one that's important to my analysis. If we decide this case exclusively under the Equal Rights Amendment, do you agree that we do not have to address the issue of a woman's right to an abortion?
Yes. However, Your Honor, we would urge you to also...
I understand that. I'm asking you for purposes of analytical clarity in my mind, whether or not I'm correct in that statement.
Yes, analytically, that is correct. I would add that at this particular moment in history, when the United States Supreme Court has held that there is no federal right to abortion, this is a particularly salient moment in history for this court to provide guidance.
And I would assume, once again, as a matter of clarity, because of course, it's all in how you frame an issue as when you drive an outcome. But my understanding is it is your argument that your Equal Rights Amendment claim is based upon the context that this is about sex, not about abortion.
That's right.
Contrary to what the Fisher Court did when it conflated those two things.
That's right. And how a legislative classification is defined is an interpretive choice that courts make. And that choice can be made to obscure and perpetuate inequality, or it can expose and illuminate it. This is a sex-based classification. It's a sex-based classification on its face. The actual impact of the coverage ban is to perpetuate gender inequality because it harms women's ability to protect their health, to achieve financial security, to participate equally with men in education and in employment.
Counsel, with Dobbs, which you just brought up Dobbs. What you're talking about here is I perceive it as standalone with respect to Dobbs. In other words, it's Dobbs agnostic, I suppose, isn't it? Or is it? In other words, and I'll be interested in hearing opposing counsel's view on this. What effect, if any, should Dobbs have on our analysis of your complaint?
So, Your Honor, our claims are entirely state-based. So Dobbs has no direct impact other than to highlight the importance of Pennsylvania's constitutional law and the urgency of not marching in lockstep with the federal courts on this issue. The U.S. Constitution does not have an Equal Rights Amendment. The U.S. Constitution does not have, as the first thing in its Constitution, a Declaration of Rights with the kind of powerful and sweeping language that this court has frequently acknowledged reaches more broadly than the federal Constitution.
I have two questions, Ms. Frisch. In follow-up to your response to Justice Donahue's question, are you acknowledging that your best argument, in fact, maybe your only viable argument, is under the ERA and not under the Equal Protection Clause?
Oh, no, not at all, Your Honor. We think we have a very strong equal protection claim. So you look at Article 1, Section 1, and it is clear that the right to reproductive autonomy is an aspect of the right to privacy, and that discriminating in government programs against the exercise of a fundamental right is not permitted under those equal protection provisions.
I understand. I thought that I heard you say in response to Justice Donahue's question, though, that your better argument was really under the ERA.
Your Honor, the other states that have looked at this question under their state constitutions are all over the map. Only 2 others have decided under the state Equal Rights Amendment, but I would direct the court's attention to New Mexico Right to Choose versus Johnson, which has an extraordinarily excellent and deep analysis. Other courts have decided it under their equivalent of equal protection.
Okay.
And either one is viable.
Go ahead, I'm sorry, Mr.
I'm sorry, Your Honor. Either the equal protection or ERA would, either one alone would be completely sufficient to support our claim.
Okay, go ahead, Justice Dougherty.
I was just playing devil's advocate. You indicate that your strong argument is Article 1, Section 1. And playing devil's advocate, in Article 1, Section 1, it also gives all Pennsylvanians the right to defend life. How do you compete termination with defending life with the same article, same constitutional right?
Well, Your Honor, there is no more private and no more self-defining decision a person can make, and no decision that so affects the entirety of a person's life, and no decision more intertwined with bodily integrity and with health than decisions around pregnancy, including the abortion decision. The guarantees in the Declaration of Rights are empty for half the population without that right. And I must say, the Medicaid coverage ban is not the way to advance the state's interest in protecting potential life.
Which brings me to another follow-up question on that. If this court were to agree with your argument, we would be diminishing legislative authority to appropriate, which is constitutional. Why is their constitutional rights less than yours?
So, Your Honor, my colleague will address some of those issues in his standing and intervention argument, but the Declaration of Rights gives sacrosanct and indefeasible rights to individuals, not to institutions, and applies to the women of this Commonwealth. And
Jump in on that.
Yes.
Follow up Justice Dougherty's question. Justice Dougherty asked you about the language defending. What? It's on.
Maybe you have to pull your.
I've never been accused of not being loud enough. Like, there's a first time for everything. Counsel, my colleague Justice Dougherty asked you about the language in Section 1 of Article 1, defending life. So I want to ask you sort of what might be seen as a bunny in the hat type aspect to your argument. Because is it built on the presumption that we draw the line in favor of your understanding of when life begins? In other words, who decides, do we need to decide when life begins to decide this case, or do we not? Because apparently the legislature has made a decision on that question contrary to where you judge it to be. And if I'm right about that, then are you asking us to draw that line, and if so, on what basis? I guess that seems to be something that's maybe skipped over here.
Your Honor, we're asking for the recognition of a right of reproductive autonomy, and that is a personal right. And I don't make that decision for others, and neither with respect does the court. Just as it would be impermissible for the Medicaid program to subsidize only abortion and not childbirth, it is impermissible for the court to exert for the state to exert a coercive effect or penalize a person for following their conscience in this matter. The interest in fetal life does not relieve the state of the obligation to provide equitable health care in harmony with the Equal Rights Amendment and the equal protection provisions.
My question, I guess, let me focus my question. Because I think there are elements of your answer there that sharpen the inquiry. You mentioned fetal life, and you mentioned health care. And I take it the opposing view, at least partly, is that that this is not health care, that this is termination of a life. And I guess my question is, do we need to decide that issue to decide this case? Do we need to make a judgment as to when life begins or what interest prevails? And if so, does the legislature's apparent position weigh on that analysis at all?
Your Honor, the court does not need to declare whether it supports or opposes people's decisions about their pregnancy. The court simply needs to see that flowing from Article 1, Section 1, reproductive autonomy permits individuals to make that decision for themselves.
I'm sorry, go ahead. Finish your answer.
Just that there are less intrusive ways to promote maternal and fetal health than to commandeer a pregnant person's body. And coverage bans actually harm the state's interest in in potential life.
Ms. Frischman, it seems that a lot of your arguments are policy-based, particularly when you got into, the negative impact on race, women of color, et cetera. Has the General Assembly ever revisited the Abortion Control Act since 1982 or since 1985 when our court upheld it in Fisher?
Yes, there was a period in the 1980s, Your Honor, when the General Assembly was passing abortion control acts every single year. So yes, it absolutely has revisited the issue over and over and over again. And I guess part of what your questions may be getting at is if the standard is at least strict scrutiny, will states continue to be able to regulate abortion? And,
and I'm sorry, finish your answer.
there is absolutely no reason why the same level and type of regulation of medical practice couldn't apply to abortion as to other kinds of medical practice.
Here's the problem, and this case, simply because it concerns funding for abortion, this case is not, as it may be perceived to be by others, this is not a pro-life, pro-choice case. This is fundamentally a right to funding case. And I understand your argument. I understand your view of our court's unanimous decision in Fisher in 1985. But in view of stare decisis and in view of the narrow issue of funding, I think it's a much more focused analysis that we need to engage in rather than the entire policy matters of did we agree with Dobbs, or does this impact other communities, or is it a pro-life, pro-choice question. Fundamentally, this case is simply about Medicaid funding. So I'm just going to give you another chance to focus your argument simply on that.
Your Honor, it is not a case only about Medicaid funding. It's about coverage of health care. Men get it, women don't. It is sex-based. It is explicit on the face of the statute. The impact that this unfair coverage scheme exerts upon women is catastrophic. And the purpose of it, the underlying rationale of it, is to perpetuate traditional gender roles that are abhorrent to our state's fundamental charter, to our ERA and our equal protection provisions. And
Could it be perhaps because men cannot have an abortion? Could that possibly be the simple rationale?
that is the way that the Fisher Court looked at it, Your Honor, but the mistake there is in saying that if there's a physical characteristic that men have or that women have that men don't have, then it's okay to disadvantage women in that area. And so if you can give fewer benefits to everyone with a uterus, that is very hard to distinguish from sex discrimination, particularly when you look at the history of how sex discrimination has played out in our society. It has been very much focused, much if not most, on stereotypes about pregnancy and women's incapacity to do anything but bear children. And
But my line drawing question, I want to come back to my line drawing question because you just talked about disadvantaging women. and it's a very clear argument. I think, we get that. And from the perspective of the other side of the table, and as embodied in the statutes, they're interested in disadvantaging the unborn child. That's, we've got the homicide of the unborn child statute, 182604, for example. And my question to you is, what is the best constitutional argument you have for us trumping that legislative policy?
So women have constitutional rights and are protected by the Declaration of Rights. Fetuses do not. The interest at stake is a state interest, not a personal interest of a fetus. It's a state interest in promoting potential life and also the life and health of the woman. When you look at the purpose of the Abortion Control Act, an equal purpose is to protect the life and health of the pregnant woman. Now, if we take the legislature at its word, that means that the Medicaid coverage ban is actually undermining that purpose. States that do not cover Medicaid abortion have a 16% lower risk. States that do cover have a 16% lower risk of maternal mortality. And so this coverage ban is not even rational. It doesn't even actually do what it says it is intended to do.
Other questions? All right, thank you very much.
Thank you, Your Honor.
Good morning, Your Honors, and may it please the Court. My name is David Cohen, and I will be addressing the issues of standing and intervention in this case and asking you to reverse the Commonwealth Court on both issues. But first, before I begin, last time I was before you, you asked me to introduce my students who were present for oral argument. This time, I don't have any who've made the cross-state trip to Pittsburgh, but I do have several who are listening online. They are 2L and 3L students at Drexel University's Thomas R. Klein School of Law, and I know they are very excited to be observing oral argument today.
Well, we welcome them and thank them for their virtual participation.
Thank you, Chief Justice. Your Honors, starting with standing, the issue boils down to the central question of who can properly challenge the constitutionality of the state's coverage ban. The Commonwealth Court found that my clients, 7 different abortion providers, cannot bring this case because they lack standing. We submit the Commonwealth Court got this wrong. In fact, if this court were to affirm the Commonwealth Court's decision on standing, it would conflict with its own past practices. In Commonwealth v. Page and Commonwealth v. Jackson, both from the early 70s, this court allowed, without comment, people who performed abortions to assert the rights of their patients. Affirming would also leave Pennsylvania standing alone among courts of last resort in this country. The U.S. Supreme Court has allowed abortion providers to sue on behalf of their patients nearly a dozen times in the past half-century without ever ruling otherwise. 11 state Supreme Courts have explicitly adopted this rule, and 12 have implicitly applied it. Neither DHS, nor the interveners, nor the Commonwealth Court has pointed to a single decision to the contrary, and providers have been unable to find one on our own. Simply put, affirming the Commonwealth Court here would be a complete aberration in Pennsylvania practice and American law. In finding no standing, the Commonwealth Court applied the special test from the U.S. Supreme Court from Singleton v. Wolf for third-party standing. However, this court, despite facing many cases of third-party standing over the decades, has never adopted Singleton and has no need to do so here. As you explained just last week in K&L, in Pennsylvania, to quote, "The doctrine of standing is a judicially created tool intended to winnow out litigants with no direct interest in the matter. This court's traditional standing test from William Penn Parking guides this inquiry, and at the heart of this test is the question whether the plaintiff is an aggrieved party. 3 factors go to this point: substantial, direct, and immediate. Each of those factors is present here. On substantiality, in paragraphs 84 through 87 of the petition for review, providers have alleged extensive injury to their own interests, harm that goes far beyond, yes?
Right there. The injury is on with regard to their ability to make profit from this indigent woman?
Your Honor, a couple things in response. First, financial injury has always been enough in this court to find harm under the test for standing. One of the issues in William Penn Parking itself was that this court decided, in the plurality decision, said that pecuniary interests and other interests are enough to find the direct, substantial, and immediate harm.
Not regarding constitutional issues, though.
No, but this has been applied in constitutional issues, and one of the dissenting justices in that case said we should just limit it to pecuniary, stick with pecuniary. Pecuniary interests have always been recognized as interests that can be harmed and be sufficed to be standing. What you're getting at, Justice Doherty, is the idea that there's a difference between who is harmed and whose rights are being asserted. The rights being asserted here are absolutely the patient's rights. However, the providers are harmed because of the denial of those rights, and that alone has been sufficient in a series of cases from this court and every other court that has addressed third-party standing.
So you're suggesting that standing has to be a completely separate analysis from when we get to the merits of the constitutional issue?
Correct. That the rights that can be asserted, as long as the party before you has substantial, direct, and immediate harm, that is enough. Here, all three of those are present, even more so than in William Penn Parking. The injury is substantial because it is different than the ordinary Pennsylvanian. We have 7 clients who are suffering in various ways, as we explain in the petition in paragraphs 84 to 87.
Let's follow up, sir. With regard to the immediate harm of a provider, it being financial, how is it immediate when they'll perform the procedure and then bill the state, and then it takes time for the state to get the invoice, process it, and pay them? I'm failing to see the immediacy, very much immediate with the person on the table or the chair. So share with me how we get around the immediacy prong of standing.
Your Honor, the immediacy is evident because it is the providers who are forbidden by law from even billing. The situation you just described would be a felony and subject to them to 7 years in jail and $15,000 fine, because the Pennsylvania Code, 55 PA Code 1101, 75, and 76, makes it a crime to bill for something that is not covered.
Would the appropriate remedy not be a preemptive declaration?
No, Your Honor. The constitutional challenge because the harm is already happening, because they do not bill, they are already being harmed, because they are covering the procedure for some, they are adjusting how they interact with their patients to talk about something that is not related to medical care, and their staff time is adjusted because of this coverage ban. This court and the U.S. Supreme Court has said repeatedly that when it is the transaction between the government and the party before the court that is direct and that is immediate. It is the transaction between the government in paying the provider that is what the coverage ban bans. It bans the billing and the coverage of that and the reimbursement of that. That is a much more direct harm than what was present in William Penn Parking.
Could you provide me the sites of the 2 cases you indicated with regard to the doctors who had standing?
Commonwealth v. Jackson and Commonwealth v. Page. Their Page is 1973. Jackson, I believe, is 1970. We have them in our brief, the Page sites. Again, Your Honor, neither of those cases was standing addressed, but it was assumed. Because
That's what I was going to say. My recollection was that
No.
standing wasn't addressed.
No, and I don't want to represent otherwise. It was assumed.
But you gave that inference.
No, I said the practice was to allow them to have standing, because if they didn't have standing, they wouldn't have been able to assert the rights of their patients. I do not want to give any impression
Fair enough.
that standing was addressed in any way, but rather assumed, because if they did not have this ability to raise the rights of their patients, the case would have ended right there.
But those cases involve the rights of the patient's privacy rights under the HIPAA type of format. And I think the argument in those cases was that the patients wouldn't have had any indication or knowledge except it's a little bit of a different scenario.
Well, that is not true with the abortion case. I think what you're referring to is how the Commonwealth Court tried to differentiate the dental case from the Commonwealth Court about privacy. And that is certainly a difference that the patients didn't know, but it was still the patient's rights that were at issue. And the patient's rights are at issue here, and it's the same in the abortion cases.
Does it matter that,
Well, just-
most,
I-
oh, I'm sorry,
the
Justice.
difference was that in the dental case, the patients didn't know their rights were being breached by the delivery of their dental records. But in this case, you really don't have that argument.
You're right, Your Honor, that it's different in that regard, but I don't think that's a difference without any kind of relevance to the inquiry here. The relevant inquiry that this court has repeatedly said is the plaintiff before the court one who has a harm that is substantial, direct, and immediate? And all three of those are present here. In applying, I'm sorry.
Well, yeah, in the related area, does it matter that that most of the cases out there involve they involve physicians, right, advocating on behalf of their patients. Here, it's the employers of the physicians. So is it one level removed or not? And if it is one level removed, does that affect our analysis?
Your Honors, House interveners who did not oppose standing before the Commonwealth Court, but now discuss it in their briefing to this court, raised this argument for the first time here. They claim providers cannot represent their patients' interests because providers are businesses and not doctors. House interveners have cited no case anywhere in the country from state or federal court that has adopted this argument, and for good reason. It has no support whatsoever in the case law. Every court that has addressed this issue, and it has been brought up to courts again and again over the past several decades, and we cite several of those cases on pages 31 to 32 of our brief to this court, our response brief, have refused this argument, have rejected this argument. William Penn Parking belies this contention itself, as the corporate entity in that case is the parking operator that was able to sue on behalf of its individual patrons. To put a final nail in this coffin, this court has repeatedly, such as in Thompson and Scampone, held that hospitals and doctors' offices, the corporate entities, have the same duty of care and connection to their patients as individual providers and individual doctors do.
Did the William Penn Parking case involve a constitutional issue?
No, it did not, Your Honor.
Isn't that what Justice Doherty was trying to get from you with regard to his questioning?
Again, I think that's a distinction in the case that doesn't make a difference with respect to standing. The standing doctrine has never differed, whether it's a constitutional, statutory, or any other inquiry. The standing issue has not made a difference. The Commonwealth Court's decision fundamentally alters the relationship between federal and Pennsylvania standing doctrine. As this court has repeatedly said, standing in Pennsylvania is more flexible, where it is a judge-made prudential doctrine, than in federal courts, where it is required by Article 3 of the Constitution. For the Commonwealth Court to use the test from the Supreme Court, which we don't believe you have to do here, but apply it more strictly, gets this backwards and makes Pennsylvania standing law stricter than in every federal court in the country. In fact, affirming the Commonwealth Court would make Pennsylvania standing law stricter than in every jurisdiction in this country. For these reasons, providers in this case ask you to reverse the Commonwealth Court and find that they have standing here. Moving to intervention, Your Honors. The individual legislators here, not the legislature, not a bipartisan representative group of legislators, are not proper interveners under Rule 2327, either Section 4, as the Commonwealth Court addressed, or Section 3, as the interveners continue to press. The holding is not only legally unsound, as I will explain, but also dangerous to the administration of justice. As this court warned in Markham, and Judge Simpson found in the original Commonwealth Court decision, intervention here would have no limiting principle to constrain individual legislators from intervening in any matter concerning their legislative function. And as Justice Doherty wrote and quoted in his concurrence in Markham, there are 253 individual legislators in Pennsylvania, each with their own concerns and interests. If the individual House and Senate members here are allowed to intervene, there would be no stopping the other members of the General Assembly from individually or in small groups doing the same, resulting in the possibility of scores of additional parties in this case and any like it. In other words, reading 2327.4 this broadly would convert the state judiciary into an auxiliary body of the state legislature. If the House and Senate interveners want to weigh in on this matter, they have a readily available way of doing so, through an amicus brief.
Counsel, with regard to Markham, that case, what I wrote was the legislators had no right to intervene with regard to the movement of an executive order of the governor. Had nothing to do with the constitutional right. Let's distinguish, that's easily distinguishable from the facts before us. This is the legislators, whether it's singular or the entire body, their constitutional right to make appropriations on behalf of its citizens. I see that as a disqualifier with regard to Markham. Do you see it similar, or do you believe that Markham is on all fours with the constitutional rights embedded in the Constitution with regard to the authority of the legislators?
You're absolutely right, Justice Doherty, that Markham did not involve that constitutional question, a constitutional challenge to a statute. It did involve the constitutional question of whether the governor has this power or the legislature has this power. More directly, involving a constitutional challenge is Robinson. In Robinson Township, there was an Article 3 challenge to Act 13, just like there's an Article 3 challenge as part of our equal protection challenge here. And in Robinson, you rejected legislator intervention there because even though, looking at the briefing in the case in Robinson, almost identical language is used from the attempted interveners, saying that we have exclusive lawmaking authority under Article 3. Replace lawmaking with appropriations. We have exclusive appropriations power under Article 3.
Well, let's look at this from a very pedestrian sense of justice. Your request is to permit the providers standing to assert the constitutional issues. But you do not want the legislators who pass the appropriations to have a say, despite the fact that your request is to interfere with their policy-making decisions in appropriation. From a fundamental perspective, for all Pennsylvanians, do you think that's fair?
Yes, Your Honor, for multiple reasons. One, you have said repeatedly that legislator standing is different. Although we think about it in similar terms as the William Penn parking factors, we apply a special test that you have applied in Robinson and Markham, that there has to be a concrete compromise to the voting process or a concrete impairment or deprivation of an official power or authority to act as a legislator. There's no question the voting process is not at issue here, so we're not talking about that. What you're getting at talking about appropriations is this idea that we're asking for an impairment of the right to appropriate money.
You are.
However, Your Honor, you have repeatedly said that judicial review, the process of judicial review, does not create separation of powers issues. In healthcare systems hospital and healthcare systems, you have said that a review of an appropriations by a court does not threaten the separation of powers and the power of the legislature because the legislature has no authority to legislate outside the bounds of the Constitution.
But that is the court, the third branch of government, or I like to say the first branch of government. It's not the only one. We're looking at the constitutional rights or the impairment of a constitutional right of the legislators. I'm just trying to get an understanding. All we want is fairness. And for those who watch and Pennsylvanians want to know that the court is the last bastion of fairness.
Your Honor, I would agree with that. And what I would say is that the legislature has no right to appropriate outside the bounds of the Constitution. And what we are not asking anyone to do is to ask you to appropriate. The Fumo case, where you permitted legislative intervention, legislator intervention. In the Fumo case, the city of Philadelphia issued a permit or a license for a casino, and the legislature claimed that we have the exclusive right to do that. That case involved a separate body, the city of Philadelphia, trying to do something that the legislature says we have the exclusive power to do. No one is asking you, the court, to appropriate. No one is asking the court to do anything that the legislature has to do. What's being asked of you is the traditional act of judicial review to set the outer bounds of what the Constitution permits. There is not a single case that the legislators have cited in a case asking for judicial review of the constitutionality of an act in which they have been permitted by the court to intervene. They submit a series of cases in which some plaintiff, somewhere, for some strategic reason, has named them as defendants, and they did not object.
What about the Supreme Court's opinion by Justice Gorsuch, who indicates in the Berger case that it's a very minimal standard to meet to be deemed an intervener?
Your Honor, the federal intervention standards are different than the intervention standards in Pennsylvania. We have to look to...
Derive some guidance from his opinion in that regard?
I don't think that's what we should do here, Your Honor. The Rule 2327, first of all, in the intervention cases that the court decided last year, the U.S. Supreme Court, they were different. The North Carolina case involved the legislature intervening pursuant to a statute under which they had the authority to do that. The Kentucky case involved the Attorney General intervening when the governor had said he would not appeal. Neither of those set of facts is at all relevant to the situation here. Moreover, Rule 2327, this court has addressed Rule 2327 without any reference to federal case law with respect to intervention, and has not used the U.S. Supreme Court analysis as the basis.
Well, the statute that we're arguing about is their creation.
Your Honor, that's a separate substantive issue than the question of legislator intervention. Legislator intervention, we have clear case law from this court, guided in particular from Markham and Robinson and Fumo, that tell us when legislators, individual legislators, can intervene. And that is not met here. Quickly, on the point of Section 3, because the legislators continue to press Section 3 of 2327 to this court, the fact that some plaintiff somewhere has named legislators as defendants simply can't be the basis of 2327-3 intervention. In none of the cases cited by legislators was there any decision on the propriety of those legislators being named as defendants. As we explained in our brief, if we had named anti-abortion activists in Pennsylvania as respondents in this case, and they didn't object because they were eager to participate in this case, that could not possibly establish any precedent that activists on an issue are now proper interveners under 2327-3. In sum, to protect Pennsylvania courts from becoming just another venue for every member of the General Assembly to voice their policy concerns, providers urge you to follow Judge Simpson's original decision in the Commonwealth Court denying legislator intervention. For the foregoing reasons, providers ask this court to reverse both orders from the Commonwealth Court in their entirety.
Mr. Cohen, that was such a nice summation, so I'm sorry to throw you off track here with an additional question, but you were asked earlier in your argument to explain the inconsistency that was perceived between your argument urging that we grant standing to the abortion providers and yet deny intervention to the legislators. Could you just compare the two doctrines and the two standards and tell us whether or not that is in fact inconsistent?
It is entirely consistent with your case law, Your Honor, for two reasons. One, the providers satisfy the William Penn parking standard for standing that has been applied repeatedly by this court for general plaintiffs and petitioners, substantiality, direct, and immediate. There's a difference.
That is the test for standing.
That is the general test for standing. For legislator intervention, this court in Markham and Robinson has said we look to whether the legislators have standing. But in determining standing, for legislators alone, the court adopted the test from the Wilt case from the Commonwealth Court for legislator standing, went through the Wilt case in depth, and said for legislators, there will only be standing under one of two circumstances. In other words, they will only meet the three-pronged factors from William Penn parking in one of two circumstances. One, when their voting has been compromised, or two, when there has been an impairment or deprivation of an official power. In applying that part of the test, the court has said in Fumo, we only apply that when another body out there, the city of Philadelphia and Fumo, is trying to do what the legislators normally do. We do not apply that in Robinson under an Article 3 challenge, or in Markham, when the governor has issued an executive order and the legislature says that that infringes upon our lawmaking authority. So there has been a specific particular test that you have developed in the context of legislator standing, which just doesn't apply to my clients because they're not legislators. So following the precedent of this court, there's two very different inquiries here. And to just finalize, to finish the point, the concern here is that there will open up the door for anyone to have standing. With providers, there's a difference between providers and the general public. With the legislators here, there's no difference with the legislators who have tried to intervene and any other legislator in the General Assembly. And as the court has said, the interest in the constitutionality of the statute is shared by Pennsylvanians generally, and they cannot come before this court trying to intervene to assert that interest.
Thank you for clarifying that. Any other questions? All right.
Thank you, Your Honors.
We'll hear from the appellees.
May it please the court, my name is Matt McLeese. I'm Deputy Chief Counsel with the Pennsylvania Department of Human Services. I'm here today on behalf of the department-related appellees. With me today are Counsel Matt.
Counsel, I hate to interrupt you, but I want to understand precisely who you're representing. You're representing the department?
Yes, the department.
The
acting
From your brief, I understand that the department's client's position actually aligns with that of the petitioners in this case. Am I correct?
In regards to which issue?
The executive branch, the administrative office, the governor's office.
Yes.
Is that your client in general?
Yes, Your Honor.
And
yes.
So you're actually taking the position that the Attorney General should be taking in this case?
We are, pursuant to the Pennsylvania Commonwealth Attorneys Act, Your Honor, we are representing the Commonwealth, the department-related appellees in defending this statute. That being said, with me today is Mr. Haverstick, who is counsel for certain members of the Senate, and Mr. Dye, who is counsel for certain members of the House. Pursuant to this court's instruction, we did divide up the issues we were arguing today. I will be arguing the issue of standing. Mr. Haverstick will be arguing the issue of the Equal Rights Amendment, as well as stare decisis, and Mr. Dye will be arguing the issue of the equal protection provisions, as well as intervention. The appellants before this court are reproductive health care providers. They do not assert that they possess a constitutional right to be paid for abortion services provided to low-income women. Instead, they seek only to assert the constitutional rights of unnamed and in many cases unknown individuals who may be their patients now or in the future. The Commonwealth Court correctly determined that they did not have standing to vindicate the constitutional rights of these third parties. It's plainly understood in Pennsylvania that in order to bring an action, you must have standing, and to show standing, you must be aggrieved. And this court's test for agreement are that the party must have a substantial interest, a direct interest, and immediate interest. We are not disputing that the appellants here have a substantial and direct interest. We dispute whether they have immediate interest. Immediate interest is shown by the causal connection between the action complained of and the injury to the party challenging the statute. Here, in cases such as this, the court ordinarily uses a zone of interest test. And what the zone of interest test indicates is that the injury that they are claiming to themselves must be within the zone of interest sought to be protected by the constitutional provisions being challenged. Here, the appellants do not meet the immediacy test because they fail to meet the zone of interest test in the sense that their injury, as they allege, are the use of their time and resources in assisting the low-income individuals obtain funding for abortion services.
Counsel, if I could interrupt, this court has never adopted the zone of interest analysis. Am I correct? That's a Commonwealth court
No,
jurisprudence?
this court has adopted the zone of interest test.
In what case is that?
They mentioned it in
Mentioned it.
William Penn Parking.
You see, William Penn Parking is not really a zone of interest case, though. I mean, William Penn Parking, to me, is the traditional approach that this court takes to standing analysis. And I guess that's what my question is to you. Why wouldn't we look at standing in this case from the perspective that Mr. Cohen has presented to the court? There's an economic interest that's involved on behalf of the petitioners. It fits into the paradigm that we set forth in William Penn Parking, and why isn't that just the end of the analysis? Since this isn't a jurisdictional issue, this is really a prudential consideration for this court as to when a party can enter the door to the courtroom.
Yes, Your Honor, and we would assert that this court has adopted the zone of interest test, and it's mentioned in numerous cases. One case in particular that we explain in our brief is the Upper Bucks County Vocational School Education Association. That dealt with a statute mandating that a school year had to be 180 days. There was a teacher strike. At the end of the teacher strike, the school board, the school district, approved of a school calendar year that was less than 180 days, not consistent with the statute. The teachers brought suit alleging that the statute was violated and it caused them injury in the nature of lost compensation and lost benefits. This court held that the teachers did not have standing because they failed to meet the zone of interest test. In particular, their loss was pecuniary, and the purpose of the statute was to protect the school year for the students. So the benefit of the statute was for the students. The benefit wasn't to the teachers. Their interest was only pecuniary. They were not within the zone of interest of the benefits of the statute itself.
But in 2010, in Johnson versus American Standard, didn't we say that you don't have to look at the zone of interest if the harm is otherwise apparent?
That's correct, Your Honor. Yes, but we would assert, as we did in our brief, that in this case the zone of interest test, I mean, the immediacy is not apparent, and consistent with Johnson, if it's not apparent, then the zone of interest test should be used. And it's not apparent really for I think for plain reasons. The appellants in their own petition for review indicate that the purpose of the Equal Rights Amendment is to prevent sex discrimination. It is not to protect providers, the appellants here, from the time and expense that they voluntarily undertake, which is commendable, but it does not protect them from those expenses that they incur.
But aren't you, in that analysis, Mr. McLeese, aren't you conflating the constitutional issues in the case itself with the requirement for standing?
I don't believe so, Your Honor, because basically using the zone of interest test, you see that the injury that they're purporting to themselves is not connected, as it should be pursuant to immediacy, to the constitutional provisions they are trying to vindicate.
Using your an analytical framework, I mean, the complaint here is about funding that's based upon sex discrimination. They are directly impacted by the funding aspect of that analysis. Why is that not the case? And isn't the funding analysis the pecuniary interest element that comes into play?
Well, Your Honor, the constitutional provisions regarding the funding itself, and whether there's a constitutional right to it, will be addressed by my co-appellees. But to answer your question, what the appellants are saying is they're taking voluntary efforts to assist women to obtain funding for abortion services, and they're saying that automatically endows them with standing to assert constitutional rights on their behalf.
But aren't they also saying they're providing services that they can't submit for payment?
That's correct, Your Honor. They are not allowed to get paid for. They're not paid for abortion services in Pennsylvania, at least from the Medicaid program.
Yeah, isn't that the pecuniary impact?
Yes, a pecuniary impact, absolutely. But once again, we don't believe a pecuniary impact, such as the pecuniary impact of the teachers in the Upper Bucks case, amounts to the ability that endows them with standing to assert third-party standing for
I
constitutional
do
rights.
wonder whether that does conflate the merits a bit. I guess your argument, as I'm listening to it here, seems in tension with the federal cases, regardless of how they came out on the merits. And given that standing is more restrictive in the federal venue, being jurisdictional as opposed to prudential here, interestingly, I think Roe versus Wade was one of the few where the party was actually the patient, right? So Planned Parenthood versus Casey, Dobbs versus Jackson Women's Health, Whole Women's Health versus Hellerstedt, et cetera. So the providers seem to be the litigants, and in the federal arena, standing doesn't seem to have knocked any of those litigants out of court, even though it's jurisdictional. Here, where it's prudential, you're advocating a more restrictive paradigm. So how is that? How does that fly?
Well, Your Honor, since Roe versus Wade, there has been case after case throughout this country where the actual individuals brought suit in their own behalf, and I cited many of them in our brief. The standard for standing in federal courts is different than the standard that has been developed in Pennsylvania. Also, many cases at the federal level, the defendants, respondents didn't challenge standing. So we don't know whether standing would exist or not, and they didn't challenge standing for whatever their strategy was at that moment. Many times they just wanted the case to proceed on the merits up to the highest court as soon as possible. So in conclusion, courts should not adjudicate third-party rights unnecessarily. The proper and best party to assert a violation of constitutional rights are those whose rights are allegedly being violated. In this case, medical assistance eligible women seeking abortion services. Thank you.
Thank you.
Madam Chief Justice, Your Honors, may it please the court, my name is Matt Haverstick and I represent the individual senators in the case.
You're becoming a regular here.
Well, you know, just as a side note, 10 years this session ago, I had my first two arguments in this court, and I think I've had 11 now. This is the first one I've had without Chief Bear. So just occurred to me while I was sitting at the table. Your Honors, there's no special justification to steer away from Fisher. It was well decided in 1985. It's been a durable case. It's been an off-cited case. And the reasons why it's been a durable precedent and an off-cited case, is that it's right. Its analysis was on the money. It was decided roughly contemporaneously with Roe and then the family of federal court cases, U.S. Supreme Court cases that define the parameters of the various rights, particularly the Medicaid funding rights. And there's no good reason, indeed no reason, why this court should disturb that unanimous precedent at this time.
Counsel, let me just ask, your opposing counsel indicated a good reason would be the right to reproductive autonomy. Why should we not consider that in 2022, that women have a right to reproductive autonomy and the legislators should not infringe or prevent that right, that there's no analogous prohibition against males? A male could get a vasectomy and probably get it paid for.
Your Honor, the reason is that's not the right you're articulating is not the right that is at stake in this case. This is not, and I'm paraphrasing, although it might be exactly what was said in Fisher. This is not a case about the right to abortion in Pennsylvania. This is, as several of you have noted, a funding case. Indeed, it's a funding case that was the result of an early 1980s legislative compromise about funding some abortions under Pennsylvania's Medicaid program, but not all abortions under Pennsylvania's Medicaid program. So what we're talking about in terms of rights is the right to have any particular, and let's assume, by the way, let's assume for sake of argument that abortion is an Article I right in Pennsylvania. That's not the issue before the court, but I mean, it was at least a U.S. Constitutional recognized right in Fisher. So let's assume for sake of argument that it is a fundamental right. We can pick that up and put it over here, because the issue in this case, just like it was with the same litigants and the same law and the same facts in Fisher, is there a constitutional right under Article I or anywhere else to have all of your Article I rights paid for by the state? Indisputably, that's a non-existent right in our Constitution.
If you frame it that way, you got a pretty good argument. But what if you frame it through the prism of the fact that the coverage ban applies only to women? I mean, that's their argument, right? It's a gender argument.
Well, I have two responses to that, and the first one, I don't mean to be glib at all. The first one is, I'm not sure that it only does apply to women, because again, we're talking about funding. We're not this right that we're talking about, this supposed right, relates to a funding provision of not the admin code, I think it's the welfare code. And imagine a family unit with single father, minor female. Single father is financially responsible for the medical expenses of minor female. If minor female is not eligible for a particular type of abortion under Medicaid, and assuming they're a Medicaid eligible family, I mean, is that any more out of bounds than the suggestion we heard a few minutes ago that the providers have a right to be in this court on this issue because of the financial stakes that are implicated?
Counsel, let me follow through on that. So what if a woman is told by her physician that it is medically necessary to terminate because of some severe condition, and she's precluded based upon her indigency, but standing there alone? Yet a male is told that he has a medically necessary procedure. He too is poor. Let's say he has a liver disease. He's permitted, she's not. Now, if we take the Fisher analysis, she's precluded because she's poor. Yet a woman of substance would be permitted to get this medically necessary termination because she can pay. How does that not conflict with the Fisher decision about unique characteristics? It never defined unique characteristics. It segregated men from women. But now we're once again following the Fisher paradigm and saying, well, we're discriminating between women because of wealth. But now we're still falling in line with Fisher. Why can't we follow that theory?
All right,
or
so
explain to me how we're not following that.
And Your Honor, allow me to do so and try to give the second half of the answer to Justice Wecht. Article 1, Section 28 prohibits discrimination because of sex. And I think that's the broader answer to both of your questions. The funding restriction is not a restriction because of sex. It's a restriction because of a particular procedure. And by the way, not all examples of that procedure, only some examples of that procedure. So, and that distinction was recognized correctly by Fisher as one that doesn't open the door to all kinds of invidious pregnancy discrimination. I mean, Fisher, I think, cited Sarah and recognized, if there are comparable conditions a man and a woman have, say for disability, and one's caused by pregnancy and the other's caused by liver disease in the man, well, you have to give them equal benefits. That's an invidious type of discrimination. But if you're somehow prescribing conduct or limiting conduct or otherwise legislating certain conduct, and when and under what conditions the state won't pay for that conduct or might or will, if it's the conduct that's being regulated, that's not because of sex for purposes of the ERA.
But men can't engage in that conduct.
Well, Your Honor,
I mean, except for that Arnold Schwarzenegger movie a long, long time ago.
well, I could go off on a tangent and say that our Planned Parenthood friends have recently submitted testimony to Congress saying men can get pregnant. But the fact that only one sex can engage in conduct has not been a determinant either at the federal level, United States Supreme Court, and these are post-Harris cases, or even at the state level in decisions recognized in the Third Circuit and other courts that per se make distinctions between men and women ineligible for legislation or regulation. I don't know how the Third Circuit didn't ultimately come out on it, but the Third Circuit in 1993 recognized in the Bethlehem School District case that indeed Pennsylvania's Fisher analysis was in the mainstream of states that have an ERA and how they look at regulation of conduct that might impact one sex more than the other. And there are areas where that's certainly permissible. And by the way, it works both ways, Your Honor. I mean, there are benefits available to women under our Medicaid program that are unavailable to men. And there's no principled reason why those wouldn't go away if this court decides Fisher's ERA analysis was incorrect, because they, for instance, relate particularly to pregnancy.
Mr. Haverstock? Oh, excuse me. Go ahead.
Counsel, let me ask you about the Fisher Court's focus on the physical characteristics of a woman that played into their decision-making here. What if, under the Abortion Control Act funding provisions, the legislature decided to fund treatment for cancer, except for cancer of the uterus? Is that permissible?
I don't know, Your Honor, and I think Fisher dealt with that, actually.
Isn't that the problem with even talking about the physical characteristics of either sex in determining whether or not funding is available?
No, Your Honor. Cancer is unfortunately a scourge that is not unique to either sex. Men and women can get it. And the cancer example that you cite is more in line with how Fisher dealt with a case like Sarah that recognized a disability caused by pregnancy is the same as a disability caused by something else.
Yeah, I don't understand I don't understand how the Fisher Court distinguished that, but that's actually neither here nor there. So, in terms of my example, will pay for treatment of cancer except uterine cancer. Your position would be that would be unconstitutional because it would violate the Equal Rights Amendment.
Because in that case, I think the only principled reason between the two treatments of cancer is sex, because both sexes can get cancer of bodily organs. There's no analog physiologically to pregnancy in men, and therefore a regulation about a pregnancy-related event, like saying we're going to pay for pregnancy but not pay for all abortions. I mean, that's the distinction that Fisher made, and I think it's the right one.
Can I ask you a philosophical question, because it's something that I've grappled with in preparing for today's arguments, which everybody briefed it well. We got lots of briefs on this. don't we have an equal rights amendment because there are physical differences between men and women? If there weren't, why would we be talking about inequality? I mean, to me, the essence of the Equal Rights Amendment is a recognition of the fact that there are essentially irrelevant physical differences between men and women, irrelevant under the law. So that's why I've just had a very, very difficult time getting my arms around this argument that only women can become pregnant, only women can get abortions. That's all true, but so what?
I confess, this has been intellectually a challenging argument too. I don't think our position is unimpeachable, but I still think it's correct, and here's why. As I see it, and as I read the ERA cases, the purpose of having the extra protection, and by the way, let's assume for sake of argument that there's a component to the ERA that's not coextensive with equal protection. I mean, I don't think that's ever been exactly decided by this court, but let's just say that,
Remind me to get back to you on that point.
lucky
Go
me.
ahead.
I think the purpose of the ERA, and look at contemporaneously with its history, is to deal with invidious discrimination based on stereotypes or outmoded norms or other historic bogus distinctions between the treatment of men and the treatment of women. I don't think that the General Assembly, in approving the ERA, intended to legislate away the possibility, or to give away the possibility, that there would be a need someday to distinguish on physical characteristics men and women. And I think we can say that safely, because in the debates on the federal Equal Rights Amendment that were in the General Assembly, I think the year after, they all noted we're not trying to say there can never be distinctions between men and women on issues such as abortion or whether some, at the time, I guess.
Just one point of correction. It was the citizens of the Commonwealth of Pennsylvania that approved the Equal Rights Amendment.
You're absolutely right. It was the voters who approved it, but we acknowledge that it was debated in the General Assembly. I mean, it was discussed.
There's all kinds of things we can find in records, as Justice Scalia was wont to observe, right?
I'm sure that there are dozens and dozens and dozens of ways to undercut any of the arguments I've made today historically. But I'm giving you what my take is on why there's an Equal Rights Amendment, and it's based on the scholarship I've had to get read up on to get ready for today.
I have one more follow-up question, and then I will cede to anyone else. We heard discussion about stereotypes that have befallen women for centuries. I think you agree with that. I think you just said that the reason that you see for the Equal Rights Amendment was to do away with the bogus repercussions of those kinds of stereotypes. Don't all those stereotypes emanate from the physical differences between men and women?
I would say no, not necessarily. I don't know that I agree with that at all, Your Honor. I think.
What do they emanate from them?
Perceptions of other than, it's a hard question, and I guess I'm struggling with it, but I don't think that, and I continue to think that what we're talking about with the ERA is ameliorating the problem of stereotypes that aren't based in physiology or facts or science, and ones that exist sort of ephemerally or have developed over time but haven't ever been really tested, and there's no good reason for them.
Mr. Haverstock, I have a hypothetical for you, in memory of Chief Justice Barrett, who loved hypotheticals. In the Abortion Control Act, the General Assembly banned the use of Medicaid funds for abortions except where necessary to prevent the death of the mother or in cases of rape or incest. What if next week the General Assembly enacted an act which banned treatment or surgery for testicular cancer except where the life of the man was at stake to prevent the death of the patient? Would that be constitutional?
Your Honor, I think it's a much harder question because of the difference between medical treatment, between the purpose of, and I suppose we'd have to understand the legislative purpose behind a distinction like that, and whether it was based on, even rationally based on, a Commonwealth policy that we could articulate. I'm not sure what policy the Commonwealth could articulate to justify that classification. I mean, I suppose if there was a legislative policy sufficiently drawn to explain why the legislature could make that classification, I mean, conceivably. As I stand here, I'm having a hard time, though, understanding the countervailing legislative policy that would warrant that kind of differential treatment. But I mean, the answer is maybe. I mean, we'd have to hear why they wanted to do it.
Well, and what would be the policy then that would support this Abortion Rights Act restriction that would not support a testicular surgery?
The policy that was raised in Harris and McRae, and then ultimately in Fisher, which is and recognized even in Casey, that the Commonwealth and any state has a legitimate state interest in promoting life, meaning life extended through pregnancy and live births, and having a policy favoring pregnancy over abortion. That's been recognized. I mean, we could debate whether that's wise policy, a correct policy, but it's been one that has been well recognized at this level and at the United States Supreme Court level as one that is a cognizable policy.
What I'm struggling with then is I started out early in this argument by explaining that this was a case about funding, not about pro-life or pro-choice, but I think maybe you're dissuading me from that statement.
Well, that's too bad. But I don't think, I think at bottom it still is a funding case, Your Honor. Nothing that the Abortion Control Act does puts a roadblock in the ability of a woman to get an abortion.
Unless she's poor, right.
But it doesn't, the government doesn't put that roadblock there. That existed regardless of the government's action. And I think that's a significant difference, and that's been, frankly, the delta between impermissible state interference with the right to abortion and permissible state activity in encouraging behavior. As long as the state is not making it more difficult for someone to exercise her rights federally or under the United States or the state constitution, it's been permissible as long as it meets a rational basis test.
But counsel, doesn't the governmental decision to fund the one and not the other require us to weigh that governmental interest that's asserted? And doesn't it all spin down, therefore, to a determination whether the relevant line drawing runs afoul of some constitutional protection?
Well, yes, but let's define what the constitutional protection is. This is where I think when you look at Maher and Harris, and I understand that they weren't ERA cases because there's no ERA, but they were instructive in defining the right. And then about a decade or so later, there was another United States Supreme Court case called Bray that articulated again and more clearly articulated the precise right at stake. And the precise right at stake, and Fisher recognized this too, almost is independent of what fundamental right we're talking about. It's whether the Commonwealth is required to subsidize our fundamental rights. That's why a rational basis test was appropriate in the U.S. Supreme Court cases. In Fisher, on the equal protection side, there was a rational basis test applied, and there still should be one today, because we're not talking about the actual liberty right under Article 1. And here we could swap out any Article 1 right. We could swap in gun ownership. We could swap in entitlement to go to private schools. If the case was about those things, we wouldn't be talking about whether I had a right to possess a firearm or whether I had a right to send my child to a private school. We'd be talking about, okay, but does the state have to pay for that right? And the answer to that, and that's why those Supreme Court cases are so important, that's the right that was viewed in those cases, and all our courts, Supreme and this court in Pennsylvania, determined that's not a fundamental right. And that's why rational basis is an appropriate test. We're not talking about the actual fundamental right. We're talking about whether the state has to pay for it. And it's why, Your Honor, as much as we are talking about the right to abortion, we probably shouldn't be. Because what we should be talking about is a funding scheme and whether the state is required to pay for our exercise of constitutional rights. I mean, you can look at the Constitution, and there are only a couple of times where the Constitution in Pennsylvania affirmatively requires the Commonwealth to pay for the exercise of our Article 1 rights. Education's one of them. I think there are one or two others, but that's not a right that's in our Constitution.
Is it irrelevant to that analysis that the government makes affirmative choices to fund any number of procedures, but then makes the decision not to fund this particular procedure, which may, and certainly in the petitioner's view, affect a fundamental right? No.
And I think, again, although it's the United States Supreme Court telling us this, I think the reasoning is sound. This is not a penalty. This is the government permissibly encouraging one type of behavior over another type of behavior. And that's why it's important to understand, and I'll say it again, the funding scheme in the Abortion Control Act isn't making it any more difficult for a woman to have an abortion than her life circumstances already would have made it for her to have one. It's encouraging alternative behavior, but it's not putting up any roadblocks. And that's the determinant for why I think the United States Supreme Court has articulated that you can encourage behavior. You can subsidize some behavior versus others, as long as it's subject to constitutional restrictions. And then they went ahead and realized, well, the way we look at the determination is a rational basis test.
All right, any other questions for Mr. Haversall? Okay, thank you.
Thank you, Your Honors.
Good morning. At least I think it's still morning time. Good morning. David Dye. I represent the House Appellees, and I would like to address the court on the issues regarding equal protection and intervention. And if I may, I'd like to kind of pick up where my colleague left off. And the questioning was regarding where are we here on the legislature's bone in the fight? What is their interest? And it's clearly stated that in the Abortion Control Act, I'll draw your attentions to sections 3202B4 and section 3202C, where they very clearly state what their policy determination is for Pennsylvania, influenced by their constituents who sent them to Harrisburg. It is to place a supreme value upon protecting human life and protecting the unborn child. And further, they state that the common and statutory law of Pennsylvania shall be construed to extend to the unborn child the equal protection of the laws. So very clearly, the legislature has established what their interest is in articulating the funding prohibition.
They have an interest in any law they pass. I mean, I'm not sure if you're saying, like, in effect, the legislatures are saying, we really, really, really care about this law more than other laws. I don't think you're making that argument. When they pass a law, they care. That's why they pass a law, right? If the governor signs it, it becomes law. So how does that argument for intervention differentiate their interest in defending any other statute, and how does that get them around the Markham versus Wolf bar? Because I think here you're making an intervention argument. I don't take that to be a merits argument, but maybe it is. But I don't understand what the principled stopping point would be. If you win on that argument, why don't you get to intervene in any case?
If I may, Justice, actually, the argument was going to the merits because we were discussing, I was trying to point out that the reason that the legislature enacted the Abortion Control Act was, quite honestly, the first one was in 1974. The Abortion Control Act in 1974, which was directly in response to Roe. The 82 Abortion Control Act was a follow-up to that, and their purpose was to identify, okay, we have an interest in protecting human life. We have an interest in the unborn child, even though we will allow for medically necessary abortions, and in the case when the mother's life is in jeopardy, absolutely medical assistance pays for that abortion, because again, a policy determination that the life of the mother, the life of the unborn child, we have to go with this one over here.
So counsel, following that theory, hypothetically speaking, say a new governor comes in and wants to pass the law, and the General Assembly passes a law vacating or excising that portion of, in case of incest or rape. It's still the will of the people by the individuals that got elected. Are you saying that, would that law now saying that no Medicaid for any abortions in any circumstances would be constitutional?
If I may clarify, if the Abortion Control Act were amended and signed into law,
they vacate that portion.
and there was no provisions for payments for life of the mother or for rape or for instance. Your question is, would that be proper?
Constitutional.
Would it be constitutional? I don't know that it would be constitutional. I can't see that happening. But if the legislature enacts the law, I'm sorry, passes the law, the governor enacts the legislation, it becomes the law. I think it stands on its own, but that's not what we have. We have.
I just asked you hypothetical because you indicated that the argument was that portion is permissible.
It absolutely is permissible, and if I can just dicker with some of the language that was used, my colleagues representing the providers that were talking about medically necessary abortions, and the Abortion Control Act permits medical assistance for medically necessary abortions.
It's actually more narrow than that. It permits abortions to save the life of the mother.
Yes, those that are medically necessary to save the life of the mother, and that's what it does not permit funding for elective abortions, and that's the difference that the legislature enacted, because that was their perception of the need of to satisfy the will of the people. If I may return to your the other half of your question, Justice, regarding intervention. The language in the Abortion Control Act doesn't necessarily get the legislature to intervene here. I was not trying to make that point. What gets the legislature to intervene here is their legally enforceable interest.
Hold on, we're not talking about the legislature intervening, are we? I thought we were talking about legislators intervening.
Well, we are talking about legislators. However, unfortunately, our law has no mechanism by which the entire legislature would intervene in masse. Our law provides for individual legislators to intervene in an instance when their ability to appropriate funds, that is their legally enforceable interest, is impinged upon. And if I may point to Justice Wecht, your decision just 2 years ago, that I think it was the Disability Rights versus Beauvoir case. You had said this is not a case where they, the legislature, allege that a power delegated to them by the Pennsylvania Constitution has been usurped by a coordinate branch of government, nor is it one where individual legislators can claim that their rights as the people's elected representatives within those legislative bodies have been curtailed. And yes, you were correct there, because they were, and as in Markham and as in Robson Township, they were piling on, to borrow your phrase. It was, yeah, a Me Too. I don't agree with that executive order either, so let me intervene and pile on. They don't get to do that, and you correctly noted that. But here, we have a legally enforceable interest. Their power delegated to them by the Constitution to be the sole determiner of how funds are appropriated is being infringed upon.
I think that's well put, but if I could follow up, I still don't see the principled stopping point in so much as any determination by any high court on a constitutional question may lead to an order on constitutional requirements for providing X, Y, or Z service. Call it Brown versus Board, call it William Penn, call it what you will, with that William Penn School District, not parking garage, right? Right. So, any
Excuse me, thank you.
determination by any high court here or in a sister state or in SCOTUS may have funding consequences for the legislative body, right? That's never been understood to afford individual legislator standing, because it's not depriving a legislator of his or her constitutional authority to vote, to deliberate, to participate in the legislature. So I'm still not understanding how your case is different from any other case in this area.
Well, I think that our case is different here because down below in the Commonwealth Court, we had discussed whether or not the appellants were looking to interfere with or prohibit the legislature from making certain funding decisions. And upon questioning, Judge Levitt was able to elicit the response that was obvious, that yes, the providers here are looking to be able to prevent the General Assembly from putting conditions on certain funding. And in pages 16 to 17 of her opinion down below, nicely summarizes how she perceived that, yes, in fact, in this case, the General Assembly's ability to determine funding and put conditions on funding was truly being interfered with.
Just one more
Certainly.
thing, and then I'll stop on this. But
Don't need to, but
I absolutely, a decision in this case in their favor could certainly affect appropriations. Just as a decision in Brown versus Board of Education had an impact on the appropriations in the Topeka School District and many others around the country, right? So, I mean, decisions of constitutional magnitude by high courts, of course, have appropriations consequences, but those decisions, when they go in that direction that you fear here, that you did not get in Commonwealth Court, obviously, they're driven by a constitutional adjudication that does not divest the legislator of his or her constitutional authority. It is a consequence of an adjudication of the organic charter. So I'm just not following that argument.
Counsel, maybe I could, this is Justice Donahue right here.
I'm sorry.
No, I didn't think it
Well,
was.
it is a question because I'm asking you to relate to that reality. If you want to stand on your prior answer, that's fine. But I see a dissonance between your argument and what's always been the case in constitutional law, which is what the case is here.
Okay, and let me perhaps put it in this light. Miranda required that now the government, the police officer, has to advise certain rights, and from that, I forget the exact case. Indigent clients are entitled to representation in certain criminal matters. Again, not civil matters and not all criminal matters, just criminal matters above, I think it's a misdemeanor too.
Gideon.
Gideon, thank you very much. It was back there. So yes, that constitutional decision, what did that certainly imposed certain requirements on the states to, okay, now we have to take this into account, now we have to plan for that, now we have to spend money here and there. Okay, but if you look at and I know I cited it in my brief, I just didn't make it to my notes, the case wherein there was a desire for public defenders to be, the district attorneys to have their pay increased when they are, even though they're only part-time district attorneys. And in that case, the decision was, no, you can't, as a group of county commissioners, require the legislature to spend this money on your district attorneys simply because you don't think that it's fair or you don't think they're getting enough money. That, and it's in my brief, Justice, I apologize for not being able to bring it forward, but that's an instance wherein, even though there's a constitutional principle that generally required the states and the general assemblies to respond with certain funding, it doesn't necessarily mean that every piece of funding that this group or that group wants has to be satisfied. And that brings us back to where we are with, why doesn't every piece of funding have to be satisfied? Because of the certain policy considerations, and that's where we're at. Is it?
Can I follow up on that,
You
Counsel?
certainly may.
many of the cases that you talked about involved a mandate, like from the United States Supreme Court, that certain procedures had to have been followed. That's not what we have here. We have petitioners who are asking us a simple question. Is this funding scheme constitutional? Let's assume for the sake of argument we say, no, it is not constitutional. We say it's unconstitutional. That doesn't mandate any one of your clients to vote in any given way. For example, your clients could decide to amend the Abortion Control Act to do away with funding for all reproductive services. And if that's what your clients and a majority of their colleagues believe their constituents want, then that's what would happen. I mean, there's no known outcome as to, the outcome of a declaration that this statute is unconstitutional. They can vote whatever they want. They could put up any bill that they want to. And it's not been unheard of that the legislature has done nothing at all in response to decisions of this court. I mean, all we are asked to do here is to answer a simple question. Is it unconstitutional? If it is, then your clients have their authority in the legislature to do what they do with amendments and things of that nature. Why isn't that the outcome of this case? They aren't asking us to order the legislature to fund all abortions. That's not what they're asking us to do. That might be a problem in terms of questioning the status of the interveners.
I think that the answer to the question is that as you review the transcript of the hearing below, it was quite clear that the petitioners were asking for something that would limit and restrict the General Assembly's ability to put conditions on this funding or that funding.
Right, if it's unconstitutional. But that's a normal kind of question that we get. And that would be a legitimate request. Tell them they can't do this because it's unconstitutional. It does not follow that we're telling the legislature to do anything else. They have their ability to come up with alternatives.
And I suppose you're right, Justice, that they would be able to say, okay, we're not going to spend any money on medical assistance or any money on health care, and would that satisfy would that satisfy that requirement that, okay, now we don't have to do what petitioners are asking us to do? Perhaps, but
You're suggesting they could make it worse? Right. In terms of funding availability?
well,
They could, right?
yes, they could, but that the ability to determine funding for this, that, or anything else is what the legislature, that's what they do. And whether it's milk subsidies, why not have to have subsidies for all Pennsylvania agricultural products? Do we subsidize solar panels? Why not give tax breaks and subsidies for coal furnaces?
Are you arguing merits now or intervention? Because if you're arguing merits, we're in a totally different universe here. There's no constitutional. There's certainly no gender-based argument around coal fire. Your hypothetical. So
I'm sorry if I lost you, Justice.
well, are we on intervention or merits here?
I thought Justice Donahue's question was going to the merits of why the legislature has any right to determine what they're going to spend money on.
Not at all. It's to the contrary.
Then I
think the
misunderstood. I
legislature
apologize.
does have a right to determine how it apportions money. They just have to do it in a constitutional fashion if the manner in which they have done it is challenged.
Okay?
I mean, that's, but that's not unusual. I mean, we hear constitutional challenges a half dozen times a year to statutes. As you're aware, as your clients are aware. I mean, you know, people come to us in all sorts of circumstances asserting that what the legislature has done violates some segment of the Constitution, and we either agree or we disagree. If we agree, then the legislature takes action that's corrective, or they don't. Or, you know, and if they do, we may see the challenge again. But our ruling on constitutionality is not a mandate that the legislature do anything.
Okay. Perhaps I'm not understanding where you're coming from, and I apologize.
Is that a question?
No. He said he doesn't understand it. I can't say it any more clearly than that. So
I apologize.
I'm going to
Justice.
cede. I will cede to you, Madam Chief Justice.
Anything else that you would like to wrap up with, Mr. Dye?
Well, I think that essentially where we are is whether or not the legislators had an ability or should have an ability to protect their constitutionally protected right to determine appropriations and how money is spent. Because that's on the table, and because Fisher told them that the funding mechanism is constitutional, and you have a right to determine funding for this Medicaid program or for that Medicaid program. That gives them the legally enforceable interest to be at the table and to defend their right to defend their funding decisions.
So that would apply in any case then? We will be seeing the legislators intervening in every case involving their decisions and their...
No, not every case involving their decisions. Only those cases which infringe upon their right to vote for a particular piece of legislation or to appropriate money in this particular fashion.
Well, isn't that what they do every day? I mean, they don't pass many laws that, or draft many laws that don't involve some impact on appropriation, do they?
Well, I see an awful lot of bridge naming cases and statutes coming through, but they do a lot of that. But that is their job, and that's why when that job is being infringed upon, they need to be able to have a place at the table and say, wait a minute, it's our duty to determine appropriations here in the Commonwealth.
I understand exactly what you're saying, but my response is, if that is correct, then there's no limiting principle as to when the legislators can intervene in any case involving legislative action that involved any sort of appropriation, which in my estimation is most of them, other than bridge naming and honorariums. It's most legislative acts involve some impact, positive or negative, on appropriations.
Respectfully, no. If for instance, and I think Wilt B. Veal is an example of it, the legislature determined that this particular building was going to be used for a particular purpose, housing purpose, and then the administration decided to use it for a mental health facility. They came in and said, wait a minute, we said the money was supposed to do that. We dedicated that building for that purpose. that wasn't sufficient for them to intervene because their actions were passed. They had the issue, they aired it, they debated it, they voted on it, and that legislation passed. Their interest there ends. And that's the way it is, quite honestly, with most of the legislation they pass. But it's only when there is something that futuristically impairs their right to determine how scarce public funds are going to be allocated. In that situation, yes, they would have the ability to intervene.
Doesn't that extend to every single imaginable adjudication that one could think of? It seems to be not only at war with our precedents, but a floodgates situation. I don't hear you to offer, or do you have to offer, any principal distinction between this case and any other adjudication one could imagine, which might bear on the constitutional obligations or powers of the legislative branch?
Justice, what I'll point to is, and perhaps it was best articulated by Judge Levitt below, is that the intent of this petition for review was to be able to interfere with and prohibit the legislature from making future spending decisions and setting future conditions on how medical assistance funds would be paid. Perhaps Justice Levitt articulated much more clearly than I'm apparently able to, so I apologize for that. But to hit on your other point, this isn't going to open a floodgate for, okay, now we have 200 and how many legislators wanting to intervene in this case or in that case or in the next case that comes down the pike. That simply wouldn't happen because our statute governing intervention would be able to dictate, well, yes, okay, you're the next person in line, but the 2 or 3 people ahead of you, the first and second people in line, they're saying the same thing, they're arguing the same points. Your interests are satisfied by them. In this case, we have nobody else articulating the interests of the General Assembly.
Yeah, the senators.
And the senators and
There's somebody else.
well,
Fabulous job representing their interests.
and while the senators are able to do that, so are we. However, the original respondents took a pass on it, and the Attorney General took a pass on it. So somebody has to have the ability to step into the breach, and in this case, 2 interveners did, the Senate and the House. And certainly, if there's a part of the intervention in law in the civil.
I understand, let me try to sum this. You're saying you have a right to intervene because you have a constitutional right, your clients, to appropriate monies how they deem fit based upon their own policy decisions.
Yes.
Okay, thanks.
Yes. Thank you. I think that we would encourage the court simply to affirm the decision of the court below, simply because the law hasn't changed, the circumstances of the law hasn't changed. Right now, we're at the same place we were back in 1985, 87, 90, as we are today. The law is the same. The circumstances surrounding the law is the same. And we're at a point where if there's a true issue that's different from Fisher, okay, let's hear it. But we haven't heard it. Fisher is still good controlling law, and we're at a point where Fisher should just be followed, as well as the Commonwealth Court's decision. However, for the court to find,
Said however.
however, for the appellants to win, this court has to take several serious diversions from existing law. You have to hold that private corporations can step in and insert their customers' rights. The gun industry would well, not I'm not saying that. What I apologize if I was confusing there, but for a business or a corporation, profit corporation, as the providers have, where their only dog in the fight is how much money can we get from the legislature. That interest is, and again, not to offend my colleague's argument, is separate and distinct from the constitutional issue presented, alleged to be presented by their customers. And because that distinction is different, they're not asserting the constitutional issue.
I know that you're just trying to respond to Justice Doherty's question, but I think we are piling on a little bit here on standing. So do you want to wrap up?
Thank you. We believe that Commonwealth Court decision should be affirmed. It was sound and remains so. Thank you.
All right. Thank you all. You just did an outstanding job on these arguments, so I commend you for that. Thank you. I think we're going to take a lunch break at this time. Mr. Minner, this would be a good time for us to break. So we will return at 12:40.
L. Brown versus Harold Best individually, Structures LLC and Fred L. Burns Inc. Representing appellants collectively is Mr. Daniel Carroll Jr. Representing Mr. Brown is Mr. James Borges III.
All right. Appellant approach.
Thank you.
Thank you. Catherine Brown was severely injured and later died when she fell descending the stairs of the Oil City Library, stairs which were built by contractors a few years before. It is alleged that the stairs were defective and that Oil City was aware of the defects. Liability against the contractors is sought under Section 385 of the Restatement Second of Torts, and the question for us is whether the contractor's liability under Section 385 extends not just to hidden defects, but also to obvious defects. If that is correct, please
You got it
proceed.
right, Your Honor. My name is Dan Carroll, and I'm representing the appellants Harold Best and his architectural firm Structures. Benjamin Martin is here representing the appellant Burns, who is the contractor. I guess I was picked to speak on behalf of all the appellants because I'm the older one in the group. But this case is the case of first impression for this court. You're asked to resolve a conflict in the interpretation of Section 385, in particular Comment C, because there's a discrepancy between what the interpretation has been by the Commonwealth Court and by the Superior Court, who have considered this issue. It is our position that the dissent in the lead Superior Court decision, which was Gilbert, decided in 1983 and authored by Judge Silvestri, and the trial court in this case, and the Superior Court in this case, all who have held that the contractor is not subject to liability to the invitee in this case, where the condition that created the injury was known by the owner of the land, Oil City in this case, where the owner of the land refused the contractor's offer to correct the situation, which was spalling on the steps, and where the owner also rejected the opinion of the architect, my client, his recommendation to remove and replace the steps. Under those circumstances, it is patently unfair to hold the contractor responsible for any injury resulting from that condition. The Commonwealth Court would hold that if a contractor created a condition that had potential harm to an invitee, that contractor is exposed to liability as long as that condition exists, and that could be forever. The Commonwealth Court in this case decided that in this action it was irrelevant that the owner knew of this obvious potential harm that can occur because of not correcting the spalling, that the contractor, as I said, offered on several occasions to come in and to correct it by placing a polymer coating on top of the steps, where the architect recommended they just remove the steps and replace them. And then the owner hired an expert to offer to them suggestions on how to remedy it. And that expert said, yes, you could put a polymer coating on it. Yes, you could remove and replace it. Or you can do some intermediate repairs, just replacing the top 1.5 inches of the steps. All that was rejected by the owner. Instead, the owner, and that's the owner's prerogative, unilaterally decided not to repair this defect, the spalling, and instead to try to mitigate the dangerousness of that by inspecting and removing particles. And they did this for 4 years before the accident.
Can I interrupt and ask you a question, counsel? Sure. You're arguing the facts, and of course we took it for the question of law. Why, if the facts were as clear as you depict them, why would you not be able to obtain summary judgment or non-suit or directed verdict under even the Commonwealth Court's Gressick standard. And also, would your position require that we overrule the Prost case from this court?
To answer your last question first, it would not require you to overrule Prost. Prost did deal with preliminary objections, and at that stage, the argument made by the contractor was, look, under common law, once I've relinquished possession of this property back to the owner, I have no more responsibility. The court in Probst said, no, you could be subject under 385. They did not discuss anything about the comment C regarding whether or not the condition was open and obvious to the owner. With reference to Gressick standard, there was no question of fact in any of these cases that it was open and obvious. This trial court and the Commonwealth Court never said there was a question of fact in this case. We are assuming that the condition was, in fact, the cause of the injury to the plaintiff in this case. And because there's no question of fact that this owner knew of that condition and chose not to correct it, again, there's no question of fact.
I think they chose you to argue because you're the wisest of all of the counsel, so.
I don't know about that.
Okay, but that being said, because you are wise and you're very experienced, why isn't the problem that you are discussing taken care of by both, if it's open and obvious, contributory negligence on the part of the, or comparative negligence on the part of the plaintiff, and you would have a clear indemnification right against the owner. And so I just, I mean, it looks like if you read subsection C in the manner in which the court did, your problem is rectified by operation of other principles of law.
I would respectfully distinguish that, Your Honor. First of all, under the interpretation, we have no duty toward the invitee in this case.
Well, that's the question, isn't it? Because that's the question that this presents. What is there a duty under Section 385 on the part of your clients to an invitee?
If I could refer to the specific language of the comment, it says that a contractor who turns over the land with knowledge that his work has made it dangerous in a manner unlikely to be discovered by the possessor, they then are subject to liability both to the possessor and to those who come upon the land. So the issue
How about
is
C? How about C? Don't stop there. Go to C. Doesn't C extend?
That is C.
I'm sorry. Doesn't the predicate restatement language impose a duty on your client?
in general it does, but this further refines it, and it has been further refined since the Prost case, which was back in 1963. It has been further refined because now they're dealing with who has a duty when it's an open and obvious situation. The issue of the comparative or negligence of the plaintiff does not bear in here. The question here is, what did the possessor of the property know at the time of the incident? And they knew, again, there was no question of fact discerned by either court that heard this as to the open and obvious of it. If you have spalling and there's crumbling on the steps, it's common sense that presents potential for harm.
Okay, but let me just, maybe I just asked a bad question, distinctly possible. Doesn't Section 385 itself impose liability under the same conditions as those that apply to a contractor who makes a chattel for the use of others, et cetera?
I would refer to the Gressick case, because in the Gressick case, the argument being made by the plaintiff, in addition to a 385 argument to hold in the contractor, the condition was made by the prior owner in Gressick. They took away a safety bridge. They sold the mill to a subsequent owner. The incident happened while the subsequent owner was in possession of the mill. They made no modification with regard to not having a bridge there. In that case, one of the arguments was, well, you're a vendor of the property. You sold this property in a dangerous condition, and therefore you should be liable. And the court interpreted Section 353, which said, with similar language to the comment C in 385, the court interpreted that as absolving a duty to the prior owner who made the modifications once the prior owner had reason to believe that the subsequent owner would not discover it. And that's what the same analysis here. The issue is, was this open and obvious? This was not a latent defect, the spalling and the crumbling. And that was the same situation in Gressick with respect to a seller of a property and the vendee.
What was the section of the restatement that the Superior Court relied on?
Section 353.
Okay, but of course, Section 385 lists the relevant sections as 394 to 398 and 403 and 404. I mean,
Well-
if we're adopting the restatement per se, they are the sections that we would look to for the imposition of liability.
Well, again, the rationale is the same. It's the issue of open and obvious to either the consumer, or open and obvious to the vendee, or open and obvious to the owner of the property. Because Gressick's saying if you're an owner of a property and you make the condition potentially hazardous, or if you're a contractor and you make the condition potentially hazardous, the issue is what did the subsequent owner or the owner know about it. At that point, we have no right to go back onto that property and to do what? We have been given no instructions. We just can't unilaterally do. It's impossible.
That's why you'd be entitled to indemnification.
Well,
I mean,
we would argue that we don't even have to get to that point.
I mean, generally speaking, we look to the knowledge of the plaintiff in these types of situations, not the knowledge of the possessor vis-a-vis someone who does repairs. Isn't it the knowledge of the user who comes into play?
Not in this case, because if we were going to make that argument, in this case, the decedent's husband was aware of the crumbling. They went to that library 2 or 3 times a day for years, and they were well aware of the crumbling nature. In fact, the husband warned the wife, be careful on these steps because of the crumbling concrete. But that's not the issue here.
Remind me of the procedural posture of this case.
This case, summary judgment was granted.
Okay.
But it seems that you want to use your interpretation of comment C to trump restatement 385. And I'm not aware, and I'm asking if you are aware, of any circumstance where a comment, or I guess in this case an implication from a comment, has been used to trump the section, that being 385. And in that regard, you also don't cite 388, 396. So I guess you're making an inference. It seems you're making an inference from comment C. Do a lot of work here.
It doesn't trump it. It further defines the limitations of the exposure that the contractor might have. This is not an unlimited exposure, and that's what the dissent said in Gilbert, and that's what all the Superior Court cases have said. This provides instructions on a limitation where it's open and obvious to the owner of the property. That's what it's saying. And Silvestri, like I say, said, and we incorporate C as part of 385. That's why the comments are there.
Is that different from superseding intervening cause?
We're not arguing causation. Some of the other jurisdictions that have considered this have based their decision on a superseding intervening cause. We're basing it on this interpretation, this comment. And we're not basing it, again, on the knowledge of the plaintiff, because that arguably could be a question of fact. We're arguing this is interpretation that has been set by precedent in the Superior Court.
But if we adopt your position and pick Gilbert over Gressick, I guess, are we implicitly reversing Prost and also putting an asterisk or a flag that maybe we don't follow McPherson versus Buick in Pennsylvania?
Again, you're not overturning Prost. It never went to the comment. It never discussed the whole, because it was not an issue. That Prost was at the preliminary objection stage. There had been no evidence developed. Secondly, this is again a modification. That's why they have comments, and it has been, we've maintained, appropriately interpreted by not only Gressick, but Longwell.
Yeah, I'll shut up after this, but I think one of the disconnects between what you're saying and what I'm hearing is, I think you just said the comments are there to, did you say qualify, or you said?
Further explain.
Because although I don't go to the ALI meetings religiously like I should, it seems to me that the comments are not meant to do the work that you're suggesting, but rather are to, as I understand, on the rare occasions when I've attended ALI, they're meant to be illustrative and be helpful by providing scenarios, rather than to undermine or derogate from the comment. It's the rule itself.
That's not the position that the Superior Courts in the dissent have taken. In addition, just think of the fairness of the interpretation. Why should that contractor be liable forever when the owner knew it, when the owner had the exclusive responsibility and ability to correct the defect, and the owner doesn't? This contractor and the architect, they can't go in there until they're told, yes, you can go in there. And that's the real injustice of the Gilbert and the Commonwealth Court, in our opinions, blanket statement of 385. You make it, you're liable forever.
But we would have to overrule Proust. I mean, I just don't see any other outcome given the argument that you're making. I mean, Section 385 imposes a liability, creates a duty on a person in the situation of your contractor. You're saying there is no duty.
I'm saying it's modified by the comment, that the comment says, yeah, there's a duty, but there is a limitation, and they developed that for a rational reason over time in looking at the body of 385. It is just an injustice to make that blanket statement, especially when Proust never addressed the comment.
Counsel, are you saying that a landowner must discover the defect before, what do I want to say? Must he discover the defect before he accepts the work in order for it to be a patent defect?
No. In this case, the defect didn't appear till later, until I think it was 4 or 5 months later. What I'm saying is that the landowner has a responsibility to protect the invitees from dangerous conditions that they know about or that they should have known about. They have that duty. They've always had that duty.
Isn't that the difference between the Proust cases? The Proust had to deal with a latent defect, and this case deals with a known defect. Isn't that the distinguishing factor between this case and Proust?
Well, Proust never decided whether it was latent or not. It was a slippery floor. There was never discussion as to what caused the slippery floor in Proust. Here we know what the problem is. It's that spalling that the owner chose not to correct.
And my other question is, as opposed to your authority under Section 385 coming from Comment C, doesn't it really come from the end of the part of 385 that says, under the same rules as those determining the liability of one who as manufacturer or independent contractor makes a chattel for the use of others? And those are the sections that are tied into 385 in the sections, 388 through 394, 403, and 404. And those all deal, for the most part, with a defect that is latent.
Correct. If this defect was latent, then we wouldn't be here, because it's open and obvious. If it's latent, this comment says then you're on the hook, contractor.
Let's look at Prost. That's a wet floor, and you're arguing that the defect was latent, yet it's the whole issue of wet floor. It's reasonable to conclude that if you throw water on a wet floor, a tile floor, it's going to become slippery. The question I have for you is, how do you define latent?
Unable to be discovered, or reasonably unable to be discovered by the owner.
So do you think a tile floor, it's not reasonable to be discovered, that if I threw water on a tile floor, that you could slip on it?
They never addressed that issue.
I'm asking you.
I'm
trying to distinguish how you're determining patent from latent. So, and you're using the reasonable standard, I assume. So I'm asking you.
Well, again, latent is hidden. If it's not hidden, it's open and obvious. And in this case, this is not a question of whether the contractor had reason to believe that the owner would find it. Here, the contractor knew that they found it. That's the big thing that distinguishes this from Prost. The knowledge and the inability, after recommendations, for the owner to tell us, yeah, come in and fix this. Why don't you? And we offered to do it. And the contractor said, at my expense. And that's what the contract says between Oil City and Burns. If there's a defect and we find out about it, we want you to come in and correct it, contract. And we can hire somebody and have you pay under the contract. That's the remedies. They chose not to follow it.
And would if the jury were charged with 385 among other relevant sections, would that not provide adequate guidance for you to get a defense verdict? What I'm asking is, why isn't this a jury issue?
Because there's no duty. We don't possess the property. We don't possess the steps. To have us go through the litigation just to get a charge under this, we would again argue it's patently unfair. We just don't have a duty.
It's just one more thing on that. I hear you. I'm just looking at the section and the comment, and it seems that would require us to let the interpretation of a piece of the comment devour that rule.
You use the word devour, and I would dispute that. It just qualifies the general rule for a reasonable basis. It doesn't preface the comment by saying, here's an illustration.
All right, anything else, Mr. Carroll?
No, that's all. Thank you.
All right, thank you. Intending to argue?
No, Your Honor, that was on behalf of both panels.
Okay, thank you. Let's hear from the appellees.
Thank you. My name is Jamie Bordas. I'm with Bordas & Bordas. We have offices down the street here in Pittsburgh, and it's an honor to be here before this court. I want to extend my condolences to you all for the loss of your colleague. I lost my father a few years ago. He was my law partner, and it takes some time, but you hope that you learned something from that person during the time. I know I did, and I'm sure you all did too, so my condolences extended to you. And as I was sitting here this morning, I also noted, so my mother and my wife are both lawyers also, and I'm on my third decade.
Give you our condolences.
Thank you. You're right. But in my third decade now of practicing law, I think this is the first time I've been before an appellate court where I looked at a majority of women in front of me, and I know that they would be proud if they were here with me today. So that's something to be said here, that we're in this century now that we're doing that. So
It's only because Justice Brobson is not participating in this case that we are a majority. We appear to be a majority.
yeah, it is an unusual situation though, and like I said, I haven't done it before, so congratulations to all of you. But I want to, of course, yeah. Well, I figure, yeah.
That's right. That's right.
And all blondes too. So that's even better. Like my wife, she would say
Yes.
blondes are better.
I
She
was
says all
going
the
to
time.
point that out if you had.
It's a requirement.
Yeah, no doubt. I want to address perhaps the last point that was made there first, which is counsel indicated there's no duty because we don't possess the property. That's what he said. That would clearly require this court to overturn Prost if it were to find that there's no duty because they don't possess the property, because that's precisely what this court said in Prost, is that you can't just say, we're not here anymore, so, hey, we can't be found liable. They said when the last nail is driven, you can't say, hey, I'm out of here. And that makes a lot of sense, and Prost is still good law. And the reason it makes a lot of sense is this. Imagine the scenario where a contractor does something, says, hey, we're out of here, and then, nobody really uses the thing until they're done. Nobody's using whatever it may be. They're building a bridge, they're doing this, until they're done doing it. So the end user is never going to really, in most instances, use it until they're gone. So that's why Prost made sense and was good law.
Shouldn't it make a difference whether the defect is latent, so when the property goes back to the owner or back to the possessor of the land, like you're like, wow, he really goofed up, this stair is terrible, doesn't it make a difference whether it's open and obvious, like you get it, it's there? And
Yeah, I would respectfully submit to you, Justice Mundy, that it does and it doesn't, and I'll explain why. With respect to the owner, it does make a difference. And the reason that makes a difference is because it's your property. You're there every day. If my swimming pool is screwed up and I decide to go take a swim in it anyway, well, that's kind of on me. But if someone else does, the knowledge of the owner shouldn't be imputed to some third person simply because the owner knows it. And we know that because the restatement is clear on that. And Pennsylvania follows the restatement. And the restatement is absolutely clear on that. And I think that a couple of you have asked the question, can the comment override the actual restatement section? And I submit to you the answer is no, it cannot. But even in looking at the comment here, all the comment says is that with respect to the owner of the land, if the defect is latent, then there can be liability just like there is with respect to a third person. That's all that the comment is saying here. There is nothing that knocks any liability out in that comment. You can read it as many times as you want, and it doesn't say only if or this. There's nothing like that.
So under this condition where it was Spalding, and I'm assuming that Spalding was a open and obvious condition, you all got that it was a defect.
Well, I think that there's disputes in the record regarding that, Your Honor.
Okay. Let's assume then for my question that it was an open defect, obvious defect. When does the statute of limitations run to let the contractors off the hook?
Well, it wouldn't. It wouldn't would be the short answer, I think, with respect to two things. One is the legislature certainly could, if it wanted to, pass some type of statute of repose like it has done with respect to product liability and things like that, but it has not. Second, with respect to your question about open and obvious, I think Justice Donahue already pointed out that those types of things would be available to the defendants at trial. Open and obvious would be available. Indemnification would be available. Not only is it available, this isn't just some hypothetical, and I'm glad you pointed that out. They actually did it here. They cross-claimed against Oil City. Oil City is actually still in the case with respect to their cross-claims.
It seemed to me like it should be and maybe I'm wrong, that it should be the law of Pennsylvania that whenever a contractor comes onto a property to make something or create something, that if they leave the property with an obvious and open defect in place, that regardless of that they're on the hook for damages to anybody for the rest of their existence.
Well, here's why it makes sense, and I'll try to help you with that as best I can. The reason it makes sense is that we're looking and saying, who here should be responsible? And just because the contractor is responsible does not mean that the property owner is not. The property owner was sued here, and in fact, money was collected from the property, so they're held liable too. But here's why it's fair, Your Honor. Why should the property owner bear all the liability when they're not the ones that did the shoddy work? The shoddy work was done by the contractor. Why should they escape? Because here's the scenario. Let's say
they do shoddy work, and then 2 weeks later they say, hey, property owner, we did this wrong at your place, say your house, whatever. We did this wrong at your house, and the next day someone gets hurt, okay? Now all of a sudden it's only the property owner that's responsible, even though the shoddy work was done by the contractor. And most property owners throughout the state of Pennsylvania are not experts in construction or doing the types of work. That's why they hire people to do it. So the expectation is that if you do negligent work, if you do something that's not up to industry standard, that causes harm to someone, that you are the one that's responsible, not this homeowner who doesn't know anything about this type of thing, or property owner who hired you and paid good money to have this thing done because they don't know how to do it. You absolutely should be the one that's responsible. And just because they happen to tell you about it, or they realize that this work is shoddy, so because under the scenario they're asking this court to take, even the next day, as long as the owner knew about it, you know, the contractor would be off the hook if somebody gets hurt, even if there was no time to fix it.
Counsel, let me ask you about what I understand some of the facts of this case establishes.
Sure.
The contractor offered a cure to the possessor, and the possessor would not let them back onto the property to make the repairs.
I don't know that that's necessarily the case. They wouldn't let them back on. I think it's more of a situation as there were disputes regarding how the repairs what types of repairs should be done and what should take place. And I think that's precisely why, Your Honor, that the law provides that both are liable, because it wouldn't be fair for some innocent third person like the Browns, all right, to not be able to recover against them while they're fighting it out about how this is going to be fixed, etc. That would be very unfair. This man lost his wife as a result of this, and simply because they can't agree on the scope of repair. And imagine this scenario. You have something done at your home, and you say, hey, this wasn't done right. Contractor says, well, I think it was. Or maybe they say, yeah, I agree with you, it wasn't, but you know, we're not coming back to do it unless you pay us more. And you say, well, that doesn't make sense. I paid you good money to do it right the first time. And they're in this dispute. And in the meantime, someone gets hurt. Why should they then be off the hook simply because they want to draw this out? Or maybe they say, go pound sand.
Well,
we told you about it, but go pound sand.
Well, but let me just see if there are any limits on this.
Okay.
Contractor says, yep, that was a defective repair on our part. We'll be back and we will fix it. And the owner says, no, we don't want to shut the library down again, and we aren't going to go through that turmoil anymore. No. Why should that contractor still have a duty to a plaintiff when the contractor attempted to fulfill his duty by offering to repair, which offer was rejected by the possessor?
The answer is they may not, but that's not what they're asking.
They may not what?
They may not have they may not be responsible, but that's not what
they may not have a duty.
Well, I think
that's what they're arguing. They're saying we don't have a duty under these circumstances.
Yeah, and Prost clearly says they do.
Well, Prost didn't deal with the situation that I'm articulating, and as I said, I'm just trying to see where the limits are, because there is an unfairness facially on the notion of we tried to fix it, we offered to fix it, we showed up with our crew, and they wouldn't let us on the property. We did it 4 times, they wouldn't let us on the property, and then they get sued.
Yeah, I understand where you're going with that, and here's the answer to that. I think there's still a duty. However, they may win at trial because they may be able to put those things forth and say, hey, we tried to do this. They may win on their indemnification claims against the library, and I think that's the biggest thing, and that's why they cross-claimed. If they were forbidden from cross-claiming, then I think they'd have a much stronger case, but they're not, and they did here.
Testing those limits that were Justice Donahue asked you about, is it your view then that given the availability of cross claims and indemnity, et cetera, that there are no circumstances where they could avoid being subjected to a jury deliberation on this?
Well, I think perhaps if a trier of fact, or if the trial court would find that no reasonable trier of fact could find that the defect wasn't open and obvious to the third person, then perhaps summary judgment would be appropriate in that instance. If they would find that, look, no reasonable jury could find that this wasn't open and obvious to the third person, then perhaps I think that would be a limitation there, Your Honor.
But wouldn't it be a limitation if what the law held in this circumstance is if an offer to cure is made and rejected, the contractor fulfills its duty to the potential injured victim?
Well, I don't think so, Your Honor, and the reason I say that is this. If Pennsylvania is following the restatement, I think the restatement makes it clear, and that's not within the restatement. That, you know, they thought that through when they wrote the restatement. They could have included that in the
But
section.
we think too.
I know, no doubt, no doubt. But this court has consistently followed the restatement, and so that would be a significant departure by this court to not follow the restatement.
Well, consistently is a strong word. I mean,
Yeah.
we applied it in one case, and then the Superior Court and the Commonwealth Court have a disagreement as to what the restatement actually holds. So, I mean, you could consider this our first dive into a situation like the one we have before us, or the application of subsection C.
Well, I'd like to mention that as well about the one time. You know, the Commonwealth Court, or excuse me, the Superior Court in Gressick. There's a Gressick 2 also, which I think is important. You know, where this court, you know, specifically stated in Gressick 2 that we merely note that the intermediate court's affirmative answer to the question is as discussed contrary to the holding reached by the Commonwealth Court in Gilbert, and that it's not obvious from Section 385's plain text. So I think that this court strongly called into question the reasoning of Gressick 1 and Gressick 2. So I think it's really been, you know, there have been multiple times, and of course the most recent court in Pennsylvania to address this issue is the Commonwealth Court in this case, you know, and below. And I think that, you know, in looking at the reasoning and rationale of Judge Levitt, Judge Brobson, and their colleagues, you know, it makes it, you know, they set forth very clearly this is what Section 385 says. And following Prost, following the restatement, there's good reason for that, and there's a reason that that's the law. And that's the most recent court to look at this. And just like the Supreme Court of New Jersey has done in other places, you know, this should be the law in the state of Pennsylvania as well. But I think that the other issue that we've touched upon, but we haven't really talked about a lot, is what happens with respect to if some other method or other approach is taken. What would the time limit be? Is it a day? Is it 2 years? Is it 3 years? And the bottom line is the restatement's silent with respect to that, and that's why those are all issues for the jury to consider. It's not proper for summary judgment, and there should not be a bright line rule that once an owner of the property is made aware of a defect, that absolves the contractor from liability. That would create a real problem, I think, in Pennsylvania in this area of the law.
That's a broader rule, though, than what we're examining here, isn't it, Mr. Bordas? I thought we were really looking at whether there could be a common sense application of this factual circumstance and whether it would be, in effect, a complete defense, if true, if there's no dispute as to the contractor's offer to cure and the rejection of that offer. Isn't that something that should be resolved pre-trial, and why should a contractor who has that arguably complete defense have to go through a trial to verdict and then perhaps be pursuing indemnification if it's clear that there's no question of fact and this is that we would view it as a common sense matter as a complete defense?
Well, I think therein lies the rub. I mean, I think because it's unfair to the third party, the innocent party with respect to this, that, you know, that these two were the ones that were involved. So, and that's why I think that the restatement takes the approach it does, which is that vis-a-vis the contractor and the owner, if the owner gets hurt and they knew about it, you're out of luck. I think that's exactly why that distinction is there, Your Honor. But as it pertains to innocent third parties, no way. And we do that in all kind of areas of the law where there's indemnification and things like that. It's not unique to a premises
But they're
liability.
not without, the plaintiff is not without a defendant to sue. This is just a question of the contractor's
Well,
liability.
maybe not in this case. Maybe not in this case, but in a lot of cases there could be.
There's a cap on damages in this case also, correct?
There is, Your Honor. Yes,
There is a limitation.
there is $500,000, which was paid in full, but we're talking about the loss of a life here, of course.
But I think that, that there are other situations too where there is no defendant, owner defendant, where there's collectability, where there's a business is something's gone out of business, bankrupt,
Judgment proof
different things.
defendant,
Yes, a homeowner that has no insurance. There are a whole host of scenarios, and I think it brings us back to who created the dangerous condition in the first place. The law has a strong preference in holding those that created dangerous conditions to be the ones responsible for it. And there's no question that the owner is not the one that created the dangerous condition. This isn't something where, hey, there's a dangerous condition on the property and I want somebody to come in and fix it for me that I created, because that happens sometimes too.
But arguably, Mr. Bordas, the owner created the defective condition by refusing the contractor's offer to correct it.
Well, I think that...
Or perpetuated it, if not created it.
Well, I'm not sure. I think that would depend. I don't think that's. I think that would depend upon a very much a factual scenario, and then we're getting into facts as opposed to interpreting the restatement.
And is there a dispute of fact on this issue?
Yes, there is on a number of issues.
But on this particular issue, the offer to cure and the rejection of the offer.
Yeah, there was a great deal of back and forth about how about what the proper method was, because it'd be like somebody saying, hey, look, you put the bad siding on my house. Use that as an example. And they say, okay, we'll come put new siding up. And I said, well, no, I don't want you to put just on that side, because now it's not going to match the other parts that were good. You got to redo the whole thing. And they say, no, I don't want to do it. So yeah, I mean, there might be an offer to repair, but it's not something that's agreeable to everyone.
Is that the case here in
Well,
this factual circumstance?
There was a lot of back and forth as far as
Without resolution.
Yeah, without resolution. There never was some type of, hey, this is what's going to be done, and then nothing happened, and then Mrs. Brown died, unfortunately.
Of course, this could be taken care of in the contractual relationship between the possessor and the owner. If the contractor had a provision that required re-entry to correct problems.
That's true. I think that could be done. There could be contractual indemnity as it pertains to those two, of course, not with respect to my client.
Well, that wouldn't actually be indemnity. That would be
Or a breach of contract.
A required re-entry to correct a discovered defect or something of that nature. Okay.
All right, you want to sum up?
Well, yes, I thank you. I think in summary that we believe that Prost remains good law, that this court would have to overturn Prost in order to find for the appellant here, that Gressick 1 is inapplicable because it didn't even involve a contractor. It involved a prior owner of a business, not a contractor at all. And Gressick 2 this court significantly called into question the Gressick 1 and said that the restatement section wasn't even applicable. That Gilbert is correct law, which has been decided by the Commonwealth Court, and that the Commonwealth Court below, in this case, just decided last year, was absolutely correct in assessing what the restatement says, that the restatement section controls, comment C does not control, and even if comment C were to control, the only thing that it does is make contractors additionally liable to owners of land if the defect is known. So we would respectfully request that the decision of the Commonwealth Court be upheld.
Thank you. Very well argued by both. Thank you.
Thank you.
Commonwealth of Pennsylvania versus Rosario, representing the Commonwealth, Mr. John Friedman, representing Mr. Rosario, Mr. Herbert Brown.
Good afternoon. In this case, we are asked to decide whether a trial court may revoke a defendant's probation for new crimes committed while he is on parole and where his term of probation has not yet commenced. In answering this question, we must address the Superior Court's 2021 en banc decision in Commonwealth versus Simmons, where the court held that a trial court may not revoke a defendant's probation under these circumstances. In so doing, in that decision, the court departed from 40 years of Superior Court panel decisions, holding that trial courts may anticipatorily revoke probation under these circumstances. If that was roughly correct, please begin.
Thank you, Chief Justice Todd. Good afternoon, Chief Justice, fellow justices. My name is John Friedman, Deputy District Attorney, Washington County, on behalf of the appellant, the Commonwealth of Pennsylvania. As Chief Justice indicated, the issue in this case is whether the Superior Court erred by holding in Simmons that consecutive periods of probation could not be violated until those terms or periods of probation had begun. The en banc Superior Court panel determined in Simmons that the Superior Court's precedent going back to Commonwealth versus Wendowski, decided in 1980, over 40 years of precedent, was incorrect. In those 40 years of precedent, that had informed and guided the sentencing courts in crafting their sentences and in crafting sentencing schemes that may include or included probation terms based on the court's and the parties' understanding of what the possible sanction, possible violations could be. As a policy matter, not only did the courts rely on Wendowski and its progeny in fashioning sentences, the parties, both the Commonwealth and defendants, relied on Wendowski and its progeny.
Counsel, can I ask you, I mean, I don't really understand your, with all due respect, I don't understand your stare decisis argument, because we're certainly not bound by Wendowski or Simmons or anything the Superior Court says or does. I'm interested in knowing what part of this policy aside and what people have done aside, where in the statute is the language that allows for anticipatory revocation?
Where in the statute is it?
Yes.
Well, the statute is silent, both that it can be done or that it cannot be done.
Well, I guess let me call your attention then to subsection D.
Are you talking to 9771?
Yes, sir.
Okay.
9771D, yes, sir. Very bottom of the statute. Record of the sentencing proceeding together with evidence of the conduct of the defendant while on probation. So he's not on probation yet. So how can he violate anticipatorily? I mean, I understand your policy arguments, though he can be punished for the crime anyway, so it's not like he's going to go without punishment. But putting the policy aside regardless, how do you get the authority in the statute for this, no matter how long? If a mistake's been perpetuated, that's not an argument for continuing it into the future, is it?
If the interpretation, let's say if Wendowski was wrong from the beginning, I would agree that it's not a reason to continue doing bad law going forward. But I think if we read 9771 in total, and we have to read B and D. So B says, revocation, the court may increase the conditions, impose a brief sanction, or revoke an order of probation upon proof of the violation of specified conditions of probation. As we know from this court's decision in Foster, specified conditions are those specified by the court plus any new violation. Then we get to D, which says a hearing is required. There shall be no revocation or increase of conditions under the section except after a hearing at which the court shall consider a record of the sentencing proceeding together with evidence of the conduct of the defendant while on probation. I don't know that those necessarily mean that they can't happen, or they have to happen together. Shall consider the record of the sentencing proceeding together with evidence of the conduct of the defendant while on probation. If the defendant knows at the time of sentencing, in Mr. Rosario's case, he knew at the time of sentencing he was going to have a term of incarceration, possible parole, and a period of probation. In his case, 2 consecutive terms of probation. I think it was 5 and 1 or 5 and 2, something like that. He knew at the time of sentencing, not only generally that he was going to have certain conditions that the court imposed, but he also knew generally because everybody knows you can't violate the law. You can't commit a new crime.
But there's no, he's not ordered. What is this, a concurrent sentence? I mean, are you saying at the time of sentencing, he begins serving probation sub silentio? I mean, I could envision scenarios then where if you're reading it that way, he'd exceed the statutory maximum.
I would agree, and I'm not saying that he begins serving it at that time. What I'm saying is that at the time of sentencing, he's aware of those conditions, and the conditions, whether they're specific, or in this case, the implied condition, don't commit a new crime. And because he committed, Mr. Rosario committed a new crime, although he was on parole at the time, and he suffers a parole hit from that, he also knew at the time of sentencing that he was going to have a probation that is subject to being revoked because he violated that condition not to commit a new crime.
Oh, no, well, I guess the question is there's an implied idea running through our law that someone on parole who becomes a convicted parole violator, all of his or her sentences that they have yet to serve are now in play. I'm with Justice Wecht on this. Parole is governed by statute. Probation is governed by statute. This principle that you're talking about isn't in the statute. You're saying it's just, well, everybody knows it, and we should continue with it. I'm a statutory guy, and the General Assembly has set this process here. How can we would have to ignore the statutory scheme established by the General Assembly to give you the relief that you're seeking.
Well, and I think and I hate to go back to the policy issue.
Well, I don't want to argue policy. If you want to argue policy, you should be in the General Assembly. I want to argue what the statute is and what the law is that we are and the courts are to apply. So tell me what authority we have to ignore the statute, which seems to be what you're asking us to do.
I'm not saying that the court should ignore the statute. What I'm saying is that the statute is not necessarily as clear as Simmons is saying that it cannot be done.
Oh, so you're arguing ambiguity.
As to 9771.
So if you're arguing ambiguity, doesn't the rule of lenity come into play?
In part. And this, unfortunately, is where I have to go to policy. Because now we're looking, let's say Simmons Rosario is a line. You have had sentences before that where the courts and the parties are operating under Wendowski and its progeny that these sentences could be revoked. If we want to, and I would be willing to say, going forward from Simmons 2021 forward, everybody is aware of what the interpretation of these statutes is, that the sentences, a consecutive probation, cannot be violated until that term starts. Mr. Rosario's case, 2.5 to 5, after 5 years is up. But everybody in the past, sentencing courts, plea deals, all of that, had been relying on these sentencing schemes. If this was an illegal sentence that had gone up on appeal, the appellate court would send it back to the trial court to resentence. We can't do that.
Counsel, you're saying that this defendant should pay the price of I don't mean you personally, but of a misunderstanding of the law. I mean, it says while on probation, he was not on probation, and that's what the Superior Court held in Simmons. I don't see how your argument that he should have known better can trump or can improve upon what the legislature put in this statute.
One small change, and I don't know that this necessarily makes a difference, is that Section D was added in 2019.
It would.
I understand Justice Robson's concern with regarding policy. But let me play that game with you.
Mm-hmm.
The policy of parole is that you are incarcerated, but you are out. We're giving you the benefit of the doubt. The probation is that we're watching you and we're not incarcerating you. The appropriate remedy for a revocation of parole is to do your back time and go to jail. And when you serve the finality of that, you are released on probation. Why is that not a sufficient remedy? as opposed to vacating a period of probation inclusive of a total sentence when it has not yet been achieved.
And I think that goes back to what was the court intending to do as part of its sentencing scheme. If the court's intention is to impose a period of incarceration with the understanding that, in Judge DeSalle's case, a period of incarceration with a probation term, with the understanding that if you were to violate, I could send you back for more. I could resentence you. That may be what the trial courts are anticipating, that they're cutting
That has been historically the practice of trial courts. But a misapplication of a reading of the statute does not law make. So the question becomes, one, and as the trial judge for 15 years, I understand your argument, but that's not what the statute reads. So the question is, the appropriate remedy would be revocation of the parole as a condition with doing your back time. And we say, no, we smack you for violating and you go back to jail. You don't have the ability. And then once you serve your time, you serve probation with the conditions. Therefore, if there's a violation, then we're able to violate you and maybe incarcerate you for that period. I'm failing to understand, other than, what's the word? Incorrect tradition of certain trial judges, me being one of them,
and
as to why the statute should not be followed.
And I think then it goes back to two things. One, we look to vindicate the authority of the trial courts. Trial courts who have imposed these sentencing schemes, in some cases, out of looking at some lenity towards defendants.
Well, in an abundance of caution, it was a vacating of the sentence, not a condition of probation. It was a violation which caused a violation of probation or a violation, and the judges historically just took their entire sentence and withdrew it.
Correct.
The statute, as Justice Browson indicates, we have particular statutes pertaining to parole and separately with probation, and they must be followed. Now, going back to the ambiguous nature of 9771, share with me what's ambiguous.
So B says the court may increase conditions or revoke an order of probation upon proof of the violation of specified conditions of probation. So there's no question that if there's a violation of those conditions, and B, revocation, does not have a time limit. It just says if there's a violation of the conditions, in this case, Mr. Rosario's case, the implied condition not to commit a new offense. The only limitation is a reading of D, that there's no revocation or increase of conditions except after a hearing, and the legislature then saying what the court must consider. Not limited just to those two things. The court can't consider other things outside of this. The record of the sentencing proceeding and evidence of the conduct of the defendant while on probation. I would assume that a trial court can consider whether, person's background. Court can consider the person's prior record.
But he wasn't on probation.
9771 is entitled Modification or Revocation of Order of Probation. So as Justice Weck just indicated, he's not on probation.
And if I might add to the max, the beginning part of Section D begins, there shall be no revocation unless the following takes place. I mean, you can't read subsection D independent of the rest of the statute and vice versa.
Correct.
So, I mean, subsection D clearly requires that the defendant is on probation when the conduct is committed that's an alleged violation of the conditions. I don't see the ambiguity. I mean, I think you started to make an argument earlier that under these circumstances, whatever they are, we should consider prospective application. But that brings me back to Justice Weck's question. Why should this defendant suffer from a misinterpretation of the statute, historical though it may be?
And to answer that last question, and I don't know if I answered it correctly or appropriately the first time, Mr. Rosario, at the time he was sentenced, in 2015, would have been under the same understanding as the Commonwealth, the trial court, Superior Court, even this court, that there could be a revocation of his probation. So I don't know that he's necessarily suffering anything.
Apparently not, because he's here. And he's saying the statute doesn't allow what happened to him. So
Well, correct.
He's entitled to any ruling that we enter in this case, is he not?
Yes, he is.
Should it make a difference that in this case it wasn't a technical violation, but it was a new crime?
I think that there's certainly an argument to be made for that, because if there are, although I don't know necessarily, because, again, Foster, 9754, say conditions have to be imposed at the time of sentence by the trial judge.
Isn't the most important factor in determining whether probation is an appropriate sentence for a criminal defendant is the safety of the public?
It's one of the considerations.
So if you are out on parole and you have a probation term out there extending, why doesn't it make sense that if you shoot somebody in the back of the head and try to kill them, that you would be revoked on your parole and you would be revoked on your probation for the safety of the citizens of this Commonwealth?
I agree totally, because, again, and that goes back to vindicating the authority of the court, and in Mr. Rosario's case, violating the condition that you not commit a new offense.
I'm not done yet, excuse me. And separate and apart, it would not go so much to the statutory section, but to the individual's eligibility to have a probationary sentence. That's all
Take your time.
Again,
No,
he's
just a
not
minute,
serving probation, right?
Justice Weck. Did you have a question that Mr. Friedman needs to answer?
I just was following up with my train of thought to make sure that I was tracking with the district attorney.
Okay, thank you.
Sorry, I
Justice
thought
Weck?
you were done. I'm sorry, I thought you were done. I just was coming back. Again, all of that well and good, but again, you may be talking about a different case, but in addition to the fact that presumably he can be prosecuted for any such offenses to the fullest extent of the law, he was not serving this probation yet. This whole appeal is about your desire to go back to a regime that the Superior Court invalidated in Simmons, by which courts anticipatorily revoked probation. In other words, revoked it when he was not serving probation yet. So we're clear, is that right?
That's correct. Yeah.
Counsel, this is, and just to build off of that, this is a situation where you're dealing with sentences that were handed down for different crimes.
In Mr. Rosario's case, yes.
Right. So this is not a situation where it was one crime and the sentence, the encapsulated sentence, was 13 to 36 plus 2 years of probation. He got imprisonment for one and probationary periods for several others. So we're talking about resentencing him on crimes unrelated to the crime unrelated to the parole period for which the revocation is springing from.
In Mr. Rosario's case, yes. But I don't believe that Simmons is limited just to that. If you have a split sentence, aggravated assault case, 11.5 to 23, followed by 2 years probation.
Right.
Simmons would still apply because it's still a consecutive probation.
I agree with you. I think it might be a little bit closer. But I think the answer to your point, and I think Justice Weck said it briefly, but I think it bears repeating. This is not an issue of this defendant getting off. This defendant committed a crime while on parole. These are the parole revocation is an administrative matter. It's essentially goes through an administrative process where he's recommitted, has to serve his back time, and gets, and that's the consequence that the General Assembly set forth. The probation under the theories of Simmons doesn't go away because there's nothing in the statute that authorizes you to revoke probation for a violation of parole. But presumably, he's getting charged and is going to be sentenced on the new criminal charge, at which point in time the sentencing judge can take into account the suitability of him as a defendant to be supervised, and probably is not going to give a probationary term, or maybe if the judge does, it'll be a short one. But this person's not getting out, right?
That's correct.
Okay.
And certainly in Mr. Rosario's case.
Commonwealth, share with me again. 9771 deals with all the conditions of probation. Criminal Rule 708 is a violation of probation, immediate punishment, or parole, for which it says a judge shall not revoke probation, intermediate punishment, or parole as allowed by law unless there has been a finding of the record that the defendant violated a condition of probation, immediate punishment, or parole. If hypothetically a court, the sentencing judge said, I sentence you to an 11.5 to 23 followed by 3 years probation, and a condition of your parole, should you achieve it, and probation is that you shall not commit a direct violation of this sentence. And while on parole, a violation occurs, he shoots someone in the back of the head. Does that mean that I can circumvent 9771 and go directly to Rule 708 or not? I guess the question is, do you distinguish 708 from 9771? Two different rules of criminal procedure as opposed to a sentencing statute. But we're talking about procedure here right now.
Right.
As to the violation hearing. So can you share with us what your position is?
Well, I think 708 and 9771, of course, have to be read together. 708 does not have, again, any limiting language as to when it occurs. It says you can't violate until there has been a finding of a violation of a condition. In your hypothetical, like in Mr. Rosario's case, it's a new offense, new crime. 9771 also says in B, almost what 908 says. Court may increase the conditions or revoke an order of probation upon proof of the violation of specified conditions of probation. And we're assuming, as Foster says, that not committing a new offense is a implicit condition of a probationary sentence.
Seems like quite a chain of assumptions there. I mean, we've established, and there's no dispute, that there is no order of probation in this case. And so you want to not only, I guess, put that aside, but also, I guess, also put aside the fact that if there was no order of probation, which undisputedly there was no order of probation here, that, ipso facto, there could be no specified conditions of probation.
Correct. But the
Right.
question I'm asking is, in future cases, this court is pretty direct as to where this is going to go. But I'm trying to inquire for Commonwealth and defense purposes in the bar. If, in fact, this court were to rule on behalf of the defendant and say, no, we are not permitting a violation condition to exist for a probationary sentence that had not been yet served, the question now becomes, when we read 708 procedurally, are we now alarming trial judges to put on the record at the time of sentencing, pursuant to the 97 series, that I am laying out my condition of parole and or probation, and should you violate a condition of my parole / probation, I can violate your aggregate and not just the term for which you're currently serving, AKA parole or probation. That's what I'm asking, what your position is, so that we can provide clarification to the bench and bar.
And I know that the bench and bar, certainly for us, for defendants, knowing what's going to happen or what could happen is paramount. And so I think that if a court is going to be specific, the court can let that defendant know, if you violate by committing a new offense, I'm going to revoke your parole and I'm going to revoke your probation. And if a defendant agrees to that, then I think that he may be on the hook then, because that would be a part of the sentence.
Got it.
At the very, and possibly a plea, a negotiated part of the sentence.
Got it.
Okay, do any justices have any further questions?
No.
Can I just ask briefly, why doesn't concurrent sentencing do the same thing that Justice Starkey just described?
Why can't concurrent sentencing? It can.
Well, then why would we have to add all of this language to an order? I mean, wouldn't the bench and the bar know that the sentence would have to be concurrent in order to have the result that's
Because
desired here?
trial courts rarely give probation parole concurrently.
But now they would have to if they want this to happen.
I don't necessarily agree with that, but
The trial courts could.
Could.
And I think a lot of it depends on, going back to Justice Robson's hypothetical, like we have here, different charges, different cases. It would depend on what the charges are. So if you have a 1 to 2, and you only have a 2-year, an M2 where you only have a 2-year max, you could run that concurrent, but it's essentially going to be concurrent with your entire maximum term.
Okay, thank you very
Thank
much.
you.
We'll hear from the other side.
Good afternoon, may it please the court. The,
Would you state your name, please?
I'm sorry,
That's all right.
Herbert Terrell.
Thank you, Mr.
On behalf
Crowe.
of Mr. Rosario. The Superior Court in Simmons, I believe, was guided by the prior decision in Foster. And in Foster, this court determined that first, the sentencing statutes were not ambiguous. They were clear and succinct, and they advised all as to what the law requires. Foster, in turn, also determined that the statutory language itself was controlling. That is, that there was no need for inferences or policy to be engrafted onto the various languages of statutes. In that effect, now the Commonwealth seeks to, again, engraft, I think, a policy determination that the prior Wendowski holding that each individual be law-abiding is in fact also a part of the probationary sentence. And I think that's contrary to the plain language of the statutes. I think, as Justice Webb brought out in counsel's argument, the language of the statute is controlling. Foster dictated that. The Superior Court was guided by that in rendering its Simmons decision. I think that being said, the Simmons Court was correct in deciding that Wendowski be overruled, that the policy basis for its decision, Wendowski's policy decision, was not valid because it did not evaluate or come under auspices of the ongoing rules that are current and modern today. And for that reason, because the modern statutes require that the decisions evolving around those statutes be controlled by its language, I think any deviation from that strict statutory interpretation, penal statutes as it were, is contrary to law, and I ask the court to, in fact, uphold the Superior Court decision. Unless there's any questions, I have nothing else. Yes, please. Yes.
Can you tell me how his sentence is and how this term of probation works into the current sentence?
His new sentence, I believe, is 25 to 50 years. And that this probationary sentence would start being served after he's completed the minimum or 50-year sentence. So in essence, he, at the moment of life
If he's
sentence.
paroled.
Excuse me?
Well, the probation wouldn't begin until after his max,
That's
because
correct.
you don't go on probation while you're on parole.
That's correct. And under the court's other sentencing scheme, a sentence of 5 to 15 years will be added on to his current sentence.
All right, Mr. Terrell, thank you very much. Thank you both.
Melissa and William McLaughlin versus the Dialysis Clinic Incorporated, representing Helen Dialysis Clinic, Mr. Seth Weinberg, representing Washington Hospital et al. Chairs.
Good afternoon. In this case, a patient sued the doctors who treated her kidney condition while she was admitted at Washington Hospital, alleging medical negligence. She sued the hospital as well, alleging the doctors were its ostensible agents. The doctors were employed by an independent contractor which provided physician services to the hospital. Following a non-jury trial, the doctors were found negligent and liable for damages, and the hospital was found vicariously liable. The hospital sought contribution and/or indemnification from the independent contractor for the physician's negligent conduct in treating the patient. We granted appeal to consider whether the independent contractor may be liable for contribution or indemnification to the hospital under these circumstances.
Good afternoon, Chief Justice. May it please the court. My name is Seth Weinberg of Marlowe the Party, and along with Philip Ernest of Petrogallo, Gordon, Alfano, Bosick, and Responti, we represent the appellant DCI. And before I begin my presentation, I would like to take a moment to thank the court for allowing me to appear here pro hoc vice. It is an honor. And before I also make my formal remarks, I would like to, with your Honor's permission, make a correction as to the statement of facts.
All right.
DCI is not an independent contractor. It was hired by nobody in this case. I do think, and we can discuss it later as we go on, but that's an important distinction here.
All right. Thank you for that clarification.
Thank you, Your Honor. We are asking this court to reverse the orders of the Superior Court and the Court of Common Pleas in this case, and that DCI be granted summary judgment with prejudice. If these orders of the lower court are left to stand, it will result in new causes of action being created without a full contemplation of the elements of the causes of action or how those causes of action implicate Pennsylvania's existing law of direct and secondary liability. Instead, we submit that this court should maintain the law as it has always been, and that there should not be loss transfer between two secondarily liable parties. And with regard to what the law has always been, I think it's important to recall what this court held in Burkhart and what the Superior Court has held in matter of MP and several other cases, which is the creation of new causes of action is limited to two bodies in this Commonwealth, and that is this court and the legislature. And what the parties in this case can agree upon, what the amicus can agree upon, what the Court of Common Pleas can agree upon, and what the Superior Court can agree upon is that there is no precedent from this court nor a statute from the legislature that deals with this situation. Therefore, it is by definition new causes of action, and the Court of Common Pleas should have granted summary judgment for that reason alone. That determination should have been affirmed by the Superior Court, and at that point it would be for this court to decide whether this cause of action should exist or not, and DCI would be an appellee in that context as opposed to an appellant.
Counsel, can I ask you for a factual clarification based on what you just said?
Yes, Your Honor.
You had stated very firmly that the hospital and your client are both secondarily liable.
Correct.
Okay. So you have no intention of trying to establish that should this go back to the trial court for indemnity, you have no intent to establish that the hospital has any form of primary liability that would prevent them from seeking indemnity under our law.
Thank you for that clarification, Your Honor, because it is an important point. What I would say to that is, as to the liability caused by doctors Nahata and Ganju, the Washington Hospital and DCI are secondarily liable. At this point, there is evidence that's not been fully litigated yet at a trial because DCI was not allowed to participate in the first trial, that the hospital committed other acts of negligence unrelated to Dr. Nahata's and Ganju's care. And if we are forced to go back and retry the medical malpractice aspects of this case, and if the Washington Hospital is found to be negligent, then by every case handed down from this court and Superior Court regarding primary and secondary liability, under those circumstances, the hospital would be primary liable, but we're not there yet.
But just to clarify, though, the plaintiffs, the original plaintiffs in this case, did not seek to establish independent liability by the hospital?
Correct. So what happened in this case...
That is a pure M-care thing?
I suppose. What happened in this case by the time it got to trial was the plaintiffs settled with the other doctor defendants and entered into an agreement with doctors Nahata and Ganju and the hospital that this would be a bench trial where the only issues to be tried were the negligence of doctors Nahata and Ganju and whether the Washington Hospital was vicariously liable under the M-Care Act. DCI was severed from that trial, was not allowed to participate in that trial. And so
So you want, so if it goes, I think this answers my question. I appreciate the clarification. If this does go back undisturbed, we do not disturb the Superior Court's order, and it does go back, you have every intention of pursuing sort of a new tort theory as a defense to the indemnification claim that the hospital had liability of the original plaintiffs and therefore cannot seek indemnification from you.
if I could be so presumptuous as to merely ask a question of Your Honor to clarify your question so I can give you the appropriate answer. When you say a new tort theory, do you mean a new theory in the context of this case or a new theory of law?
No,
as a whole?
a claim, you want to assert a new claim as a defense to a claim for indemnity of them committing a tort, the hospital committing a tort against the original plaintiff.
I would call it a defense, Your Honor, but yes, what I would say is that
You have to prove a tort.
I have to prove they were negligent, and therefore, by definition, under the law of common law indemnity, a party who is negligent is not allowed to common law indemnity, and it defeats the claim. Right. Okay. I mean, I would actually submit, Your Honor, that it's the hospital's prima facie burden to prove they're free from fault. That's one of the two elements of an indemnity claim. But to boil it down, the issue would need to be litigated. Yes, certainly.
If you were right, counsel, if I could follow up, if you were right, why would hospitals like the Washington Hospital use any independent contractors? In other words, they would have to hire physicians on staff, right? Because they would not want to go out and hire these employees of DCI, right? Since in your view of the law, only the hospital could be vicariously liable for their actions.
I think, Justice Weft, I have a few issues with the premises of the question.
I might be misunderstanding. Please.
Yes. So let's start with number one. The hospital did not hire Doctors Nahata and Ganju as its independent contractors. They are physicians with privileges. It's common in the malpractice field. So that's number one. Number two, I'm not suggesting that DCI is not vicariously liable to anybody. I am suggesting DCI is not vicariously liable to the hospital. So for example, in this case, what we are suggesting, what the law has always been, if the McLaughlins had sued all of the defendants they'd originally sued and DCI, and the matter went to trial, and the verdict is the same, and the McLaughlins took their $17 million judgment and presented it to DCI, they could do that. And DCI could not in turn go to the Washington Hospital and say, these are your agents for whom you are vicariously liable, same as we are, and you owe us indemnity or contribution. So what the hospital is saying is, and they don't dispute it, it's been found by the finder of fact in the trial they participated in, they are vicariously liable under the MCARE Act. And they now want to transfer that vicarious liability to someone who the plaintiffs chose for whatever reason not to sue. And what they've done in their brief, and if the court will recall, because we mentioned it several times in our brief, the hospital has acknowledged that DCI is not a tortfeasor. The hospital has acknowledged that the only tortfeasors in its minds are Dr. Nahata and Ganju. And when you read, instead of addressing that admission head on in their appellee's brief, they simply talk about DCI as if it was the doctors who committed malpractice in the case. They make no distinction between Doctors Nahata and Ganju and DCI. And that's where they run afoul of Mammalus and the law of agency and everything else that has come since those cases.
Counsel, what would the principled reason be for allowing who a plaintiff sues to control the hospital's rights, in this case, vis-a-vis your client? I mean, are you saying if the plaintiffs here had sued your client directly,
yes,
we wouldn't be here? The hospital would have had a claim over, and that would be that?
No, I'm saying we wouldn't be here if I'm correct. If I'm wrong, we're still here because we're transferring vicarious liability.
Yeah, but let's assume that the plaintiffs sued your client in their principal action.
If they sued my client as the employees of Dr. Nahata and Ganju, and Dr. Nahata and Ganju were found $17 million, and we paid the $17 million, if I'm correct on the law, we're not here. If the hospital is correct on the law, The vicarious liability that we paid for can be split between the secondarily liable parties for Doctors Nahata and Ganju. The hospital is just as secondarily liable as we are.
Well, let's say that the verdict came in against both your client and the hospital. Then who pays?
Well, the hospital would pay for its part. Dr. Nahata and Ganju would pay what they could. And then at that point, plaintiff has a choice. So let's assume, just to use a round number, Dr. Nahata and Ganju's liability was $10 million. They could pay only $2 million. To get the remaining $8 million, they could either have gone to the Washington hospital or they could have gone to DCI. If they go to us and we're correct on the law, the litigation ends.
But why does it end? Because you pay.
Because I pay and I believe the law does not allow me to transfer it anywhere.
Okay, and that brings me back to my question. Why should who the plaintiff sues determine the rights of Washington Hospital in this case?
Because it's not the right of Washington Hospital. Vicarious liability was not designed to protect Washington Hospital. That's what this court held in Milton Hershey and Mammalus. Vicarious liability was designed to compensate the...
I guess you keep saying your view of the law, and I'm not disagreeing. I mean, that may in fact be the law, but you're agreeing with me then that your argument is based upon sort of an underlying premise that the plaintiff can control the indemnification and contribution rights of defendants inter se.
No, because, for example, let's assume we're not talking secondarily liable parties at all. Let's assume we're talking 3 doctors.
Yeah, but if we aren't talking secondarily liable parties, we aren't here. Your whole case is based upon the existence of vicariously liable parties, which would have been the case had the plaintiffs also sued your client.
Again, Your Honor.
You would have been vicariously liable for the torts of your doctors.
To the plaintiff.
Okay.
Which is what this court held in Milton Hershey and Mammalus. It was designed to protect the victims of torts who cannot protect themselves.
Okay, but the Washington Hospital would have been less financially put out under those circumstances than they are here under your theory because of the fact that the plaintiffs didn't sue your client directly.
Not necessarily, Your Honor, because the plaintiff could have said, DCI has certain assets, the Washington Hospital has more assets. I'm going to choose to collect from the Washington Hospital. Plaintiff had the right to do that because we are joint and severally liable.
So this is all in the hands of plaintiff's counsel. The outcome of this case, the outcome of how payment is made in malpractice cases is all in the hands of who the plaintiff chooses to sue and who they choose to collect from.
I think it depends on the claim. And let me do it this way. With contribution, it's also in the hands of the legislature. Because the legislature, that is statutory.
Well, that's built into the plaintiffs having a choice. I mean, obviously, they're bound by whatever the contribution statute says.
Correct. So contribution is not governed by the plaintiff exclusively. It's governed by the legislature. And we would submit we're not a tortfeasor because there's never been a case.
But neither is Washington Hospital. And taking my direct action claim that the plaintiff brings. I mean,
it's not,
if the plaintiff brought a suit, and the only other thing they did is they added your client. Washington Hospital would have been liable under an ostensible agency theory. That's what they proceeded on, the plaintiff proceeded on. Your client would have been responsible under a respondeat superior theory.
Correct. And then when the plaintiff presented that judgment to Washington Hospital, should it have so chose, it would be compelled to pay. And that has nothing to do with...
And so would you. So would your client.
Not if they didn't present it to us. If they collected everything...
Okay, so you're agreeing with me. It's up to plaintiff's counsel. That's the part of this that I'm having a hard time accepting as a matter of how contribution and indemnity should work under an MCARE Act lawsuit. I mean, it just cannot be that the plaintiff's counsel has the ability to totally control indemnification and contribution rights of defendants.
Well, that may be, but then we turn back to what are the elements of indemnity and contribution. And the elements of common law indemnity have always been the party seeking indemnity must be free from fault, i.e. secondarily liable, and the party who owes indemnity must have been negligent, i.e. primarily liable. And there's no evidence that DCI was primarily liable. That's not an action of the plaintiff. That's what the law has always been. So to say it's plaintiffs controlling common law indemnity is not truly accurate because it's not a common law indemnity claim. It cannot be by definition because someone in the common law indemnity equation has to be negligent.
Can I back up to responding at Superior for a second?
Sure, Your Honor.
Why is it in the context of this case, we're talking about Dr. Nanju and Dr. Nahata, Ganju and Nahata. So why on that theory wasn't it appropriate for the issue of control over those two to go to the jury?
Well, we weren't allowed to go to the jury. That's a separate
You
issue.
agree that that's the right path to take?
Well, I would say this. If this court wants to change the definition of tortfeasor to include those who did not themselves directly injure the plaintiff, then that seems to be the cause of action. Now, I would put it this way, Justice Wecht. That's the trial court, and the Superior Court envision. But there is no case ever that has allowed such a trial, except for the Sleesman case out of the Court of Common Pleas below. And the reason we run into this issue is, what is supervision and control in the context of medical malpractice? Is it who decided every decision with Doctors Nahata and Ganju? Because they're doctors. They were alone in those rooms making those decisions. Is it the hospital who allowed these physicians in and presumably had some form of protocols as to how treatment's going to be rendered? I don't think the Washington Hospital would take the position that doctors in their hospitals can do anything they like. Is it DCI, who's, as an entity, has no involvement in plaintiff's care? Because that doesn't seem to work either. And this is the point before where I talked about expansion of law. There's no roadmap here. It does not exist. And the reason it doesn't exist is because it does not fit within 2 centuries worth of indemnity law and the 70 years of UCADA where there's a case where this has ever come up. And it's not merely because plaintiff has chosen, it's because the elements of the claims as they've always existed don't fit by definition.
Well, but I think one of the reasons this doesn't often come up, correct me if I'm wrong, maybe I'm wrong on the facts in this case. The plaintiff's lawsuit was filed close to the statute of limitations running. Am I correct?
Honestly, Your Honor, I don't know. I don't want to make a misrepresentation.
I think my understanding of the facts is that is so. And when your client was joined, the statute had run on the plaintiff's claim against your client directly.
That's correct,
Okay,
Your Honor.
so had the claim against your client have been filed within the applicable statute of limitations, whether or not the plaintiff directly sued you, they would have gotten the benefit of your timely joinder within the statute of limitations. And so, although the plaintiffs didn't fashion their lawsuit that way ab initio, that's what would have happened with a joinder of your client during the plaintiff's statute of limitations, correct?
Possibly.
Okay, because I think that's law. I mean, they get the benefit of the joinder within the statute of limitations. So I'm just grasping for why this is such apparently odd situation. I mean, what the trial court did here is I think he tried to put this case back into a context in which, when the case was tried, your client would have been part of the mix, because he did 2 things. First he ordered a trial on the direct liability, corporate negligence of Washington Hospital, okay? And then if you win that, or whoever has the burden of proof, they lose that, then the indemnification claim is over. I agree with you. But he also ordered a trial on who had the right to control the doctors, correct?
Well, the court fashioned that as contribution. That's what the court referred to as that, yes.
Correct. Okay, but so I mean, I thought the trial court, did a innovative job in trying to deal with a very awkward situation. But ultimately, it was his intention that all of these rights would be worked out in the subsequent trial. What's wrong with that?
Well, I think there's a few things wrong with that, Your Honor. And let's start with indemnity, and let's put aside the Washington Hospital's own negligence. Mm-hmm. This court's going to have to find that we can owe 100% of the vicarious liability in common law indemnity, even though we're not negligent. That's not common law indemnity as it existed to date. So we can, There's just no law for that. There's never been law for that. And I'm not even sure if we talk about fundamental fairness, how we get there, because quite frankly, let's assume for the sake of discussion that I am wrong and contribution is allowed. There's at least a splitting of the benefits of Dr. Nahata and Ganju's services. But here's the factual reality of this case. If Washington Hospital does not have nephrologists in that hospital, they have to turn the helicopter with Mrs. McLaughlin around. And the Washington Hospital cannot treat that patient. And the Washington Hospital's other providers can't treat that patient. The Washington Hospital can't bill for those services, can't bill for those medications, et cetera, et cetera. So for the Washington Hospital to say they got no benefit out of Dr. Nahata and Ganju's presence is incorrect.
It's not the benefit, it's the right to control them. They're already hit for the benefit of using them. That's what a sensible agency is. They didn't have to show that there's any control or anything. The fact that they were there under the MCARE Act means that they were ostensibly the agents of the hospital.
And what I would say is vicarious liability in all its forms, there is no distinction. It doesn't matter why you're vicariously liable.
True?
Yes, that's what Builder Supply says.
Yeah, but to me, ostensible agency is truly a commercial recognition of what happens with hospitals who use physicians that they don't employ.
But here's why, and I come back to why vicarious liability was designed to protect plaintiffs. Hospitals make the choice to use that business model, unlike a plaintiff. Mrs. McLaughlin couldn't choose to be free from malpractice. Washington Hospital could choose to employ its own doctors, could choose to hire a group of nephrologists to service their patients and get contractual indemnity, additional insured coverage, and other risk loss mitigation procedures. That's why vicarious liability exists for plaintiffs and not them. It's for those who are not in a position to minimize their own risk. That's what this court held in Milton as Hershey. That's what it's designed for. So now we're talking about, basically, we want a hospital who's an ostensible agent to have doctors come into their facilities, claim they have no control of any of the care rendered inside their facility, and then transfer the complete loss to a non-negligent party when this court is always required a showing of negligence on the party owing indemnity.
I think of the two, and you keep going back to it, you keep wanting to lean back toward indemnity. I think of the two, your indemnity argument is probably your better argument. The idea that you cannot hold one who is secondarily liable indemnity. You can't shift the loss to them. But what about sharing it? And what I'm trying to understand is, under UCADA and the definition of joint tortfeasor under UCADA, why two secondarily liable parties can't meet the definition of joint tortfeasor under UCADA.
Because under UCADA, the way it's always been considered, it's always been between parties who are directly liable to plaintiff.
Okay, now I know why it's always considered that. What about the statutory definition of joint tortfeasor?
Statutory definition is joint tortfeasor. It just says joint tortfeasor.
Well, no, it doesn't. It says joint tortfeasor means two or more persons jointly or severally liable in tort for the same injury to
Correct.
persons or property,
And
whether or not judgment has been recovered against all or some of them. Isn't someone or two parties that are vicariously liable in tort for the same injury meet the definition of joint tortfeasor?
I don't believe so, Your Honor, because because you have to go back to what this court said in Carozzo, and we're talking about apportionment and things of that nature. And traditionally, that's been apportioning the liability to plaintiff, not apportioning a piece of vicarious liability for control over joint employees or joint agents or joint principals. Even that has never been contemplated before. And I would submit that's not something a plaintiff would want. And if we go back to this specific case in Justice Dunn,
the plaintiff just wants to be paid.
No, agreed.
The issue of contribution and indemnity doesn't affect the plaintiffs on a joint and several liability claim.
No, I agree, but let's take this case as an example. What happened in this case, and I go back to Justice Daugherty's comment in an earlier case of just the pedestrian notion of fairness. What happened in this case was we weren't allowed to try the merits of the malpractice case. And because we made a motion to bifurcate, the court said, no, I'm going to sever you. You're not allowed to participate at all, which then allowed the hospital, the doctors, and the plaintiffs to enter into an agreement where we have a malpractice trial with no live expert witness testimony, where the expert evidence that plaintiff had against the other doctors is not submitted into evidence, is not to be considered. And now In its appellee's brief here, Washington Hospital says, I want summary judgment, reimburse me all of that money. And what I'm suggesting is that whatever benefits may be derived from that formal contribution is outweighed by the dramatic increase of litigation that we're going to see. Basically, every case a hospital like the Washington Hospital has today that it has settled within the statute of limitations for contribution and indemnity comes back to life. Because now they can go back to all of the groups of all the doctors that they have in their facility and say, now we want to discuss how much you control these doctors. And now these groups have to come back.
True. I'm not so sure that's true. And I'll be interested to hear what opposing counsel has to say about this. But I think a large part of the reason this case is as complicated as it is because the joinder of your client took place after the period of time in which the plaintiff had a claim over. Otherwise, this would have all been tried at the same time. And this issue of who's responsible for what and those kinds of things could have been taken care of in the original trial.
Your Honor, it's a very common occurrence that there are private attending physicians in a hospital.
No. I'm talking about the timing of the claim.
No, and it's also a very common situation where both the hospital and the employers aren't named by the plaintiff. It is not a common situation, and in fact, no one, including an amicus group that represents hospitals, has ever found a case where there's a phase of that litigation litigating supervision and control over employees or joint agents. That's never happened. And if we call this contribution and we apply the contribution statute of limitations, that's 4 years from the date of judgment. So there is no reason, unless we're going to say it's not contribution under UCADA and it's a new claim that exists now, we can't call it a UCADA claim and then say it doesn't have the UCADA statute of limitations. They have to go hand in hand. And that's what we suggest is the problem with this case. What the problem with this case is, you're right, Justice Donahue, and in a very real way, it is that we weren't named. But let's assume we were named. And let's assume the Washington Hospital's right. And they present me a judgment for $17 million. I'm going to pay the McLaughlin $17 million, and then I'm going to want my trial against the Washington Hospital to split that $17 million liability. That could have happened, I'm sure, thousands upon thousands upon thousands of times over. Certainly since UCADA was enacted in 1955. It's never happened.
Mr. Weinberg.
Why? That's what you keep
Why?
saying.
Because
So why are we here?
There
has to be an oddity in the context of this case that this is the first time this issue presents. I mean, you're right. Plaintiffs oftentimes don't sue the employer and, et cetera, et cetera, et cetera. So what is it about this case that has presented this heretofore unpresented issue?
I think it's truly nothing more than, in this case, it's an exposure the Washington Hospital did not want to face alone. And
It can't be unusual either. I mean,
But I
nobody
think-
wants to
That's
face
a pretty
exposure.
common desire.
Well, no, I understand that. But what I would say is, if you look at everything we've talked about here, if this claim is correct, if the Washington Hospital is correct on the law, certainly of contribution, if not indemnity, medical malpractice litigation has just gotten significantly more complicated. I don't know that anyone has an interest in that.
Mr. Weinberg, at the very beginning of your argument, you pointed out to me that DCI was not an independent contractor. How would you characterize it?
It's the employer of Doctors Nahata and Ganju. It was hired to do nothing. Mrs. McLaughlin did not seek treatment from DCI. The Washington Hospital did not call up DCI. Washington Hospital did not retain DCI to operate its nephrology services. It is, I wouldn't even call it an oddity of malpractice, because I think we may be coming to a world where these ostensible agency things may become more common. We all know those blue Amazon trucks. They're not all owned and operated by Amazon.
Who got paid for the services of the physicians? Your
DCI
client?
got paid for the services of the physicians.
That's what I thought.
Yes, I can't dispute that. And I'm sure, as they did in their brief, the hospital will come up here and explain how it's I believe they use the word harvesting of patients, which I think is a little more nefarious sounding than it truly is. But as I said before, the Washington Hospital doesn't have nephrology patients without doctors like Nahata and Ganju. It doesn't have a nephrology floor unless it wants to hire their own. It's made a business decision. And in that business decision, it could have made other business decisions that would have insulated itself from this loss. It chose not to.
It had no contractual relationship with DCI.
No, Your Honor. These are physicians. There could be a Dr. Smith who has his own PC, who's also a nephrologist, and Dr. Smith and Dr. Smith PC. That's very common. This is not an uncommon factual situation. I think what we have here is a litigant in the Washington hospital who looked at the law of common law indemnity, ignored the part that said DCI has to be negligent, and said, let's do that. Looked at Yukata, ignored the fact that no secondarily liable party has ever been found a tortfeasor. Let's ignore that. And let's also go back to the beginning, which was their theory has shifted over the life of this case. I think that's important to note because it does go to the complications. When we made our preliminary objections under respondeat superior, the Washington hospital says, no, this is an indemnity contribution statute of limitations. It hasn't run. Then we try to get interlocutory leave to the Superior Court, and in their answer to our petition, the Washington hospital says, indemnity and contribution aren't even issues in this case anymore. This is all respondeat superior liability. Grant a summary judgment. That's how they briefed it before the Superior Court. That's part of how they briefed it here. And so every time...
Did they win on that issue?
They've not gotten summary judgment yet, Your Honor.
No, did they win on did they win on the argument that we're only pursuing respondeat superior and not
No, because the Superior Court refused to get there because...
They get to change their position.
I understand, but what I'm saying is, you're right. I'm not saying they're judicially stopped. My point is more that when we allow these complexities into the already complex world of medical malpractice, what it's really doing, and it goes back to why, in part, Judge Lucas did what he did. He saw this case languishing, and the McLaughlins not getting their day in court. And so he said, here's what I'm going to do. I'm going to chop off the fight between DCI and Washington Hospital, and I'm going to get these plaintiffs to their verdict. And it's going to happen a lot faster that way. And now he's looking at, then comes back, and now he's faced with a hospital that wants summary judgment before DCI's had an ability to participate in the trial and realizes, well, I can't do that either. So now we have to go back and retry the malpractice trial and retrial these new elements of contribution, retry these indemnity, all the while realizing that he has no appellate law to guide him. That's why he certified this case.
I only have one more question for you.
Certainly, Your Honor.
You mentioned earlier that plaintiffs would not like it if we viewed secondarily liable defendants, like your client in Washington Hospital, as joint tortfeasors under the Uniform Contribution Among Tortfeasors Act. Why do you think that's the case? Why wouldn't plaintiffs like that?
Because unless they're going to get the contribution trial severed from their case, they're going to be waiting a lot longer to get to the end of it. And if they sue both...
But it could be severed, correct?
No, it shouldn't be severed.
But it could be severed.
I think that's going to result in the inequitable and unfair results we have here. Because one of two things is going to happen. If it's severed, it needs to be retried because one of the parties didn't have an opportunity to try several issues. Or it continues, and now there's a whole phase of litigation in the main trial where we're talking about who controlled Doctors Nahata and Ganju. And I would direct this court to 1399 and 1400 of the record. I think it's telling pages where Judge Lucas was explaining how even if the Washington Hospital didn't move to bifurcate, which resulted in severance, he was going to sever the case sua sponte for two reasons. Well, really three, I should say. He felt it unwieldy as a whole. He thought it would confuse the jury. And he was concerned that the court would create more errors that would result in more appeals, would slow down the plaintiff's litigation. If plaintiffs had brought us in, the biggest difference here is plaintiffs would be sitting at one of these tables. They're still in the case. They have no skin in this game. None, because they got their compensation.
Okay, Mr. Weinberg, thank you very much. Let's hear from the appellee.
Thank you, Your Honors.
Obviously, it's a very simple case.
May it please the court. Your Honor, Tom Chairs for the Washington Hospital. Chief Justice Todd, if I could go back to your one of your final questions. Who is DCI? If I could define for the court...
Well, I actually asked, what is DCI? But it's the same question, I guess.
What is DCI? Okay. DCI is the employer of two physicians that caused the $17 million loss. Okay? They are, by contract, the only entity that can bill for the services. By contract, these physicians can only operate or do professional services at physicians within the furtherance of the business of DCI.
Because they are contractually obligated to DCI.
Okay, absolutely. The contract is so complicated and so specific. It actually has a provision that DCI retains the right to demand that these physicians go out into the community and obtain privileges at hospitals and take call on their nephrology service for the absolutely crystal clear purpose of making physician-patient relationships in community hospitals. And then when those kidney patients require dialysis, they incentivize those physicians to come back to the DCI clinic, which is where across the country.
So counsel, how do you?
Let him finish that answer, if you would.
Across the country, from Pennsylvania to California, they have a model that makes money. It prints money. They have they have a lot of resources. Their litigation tactics in this case are evidence of it. They filed 5 motions for summary judgment on the same issue. The judge was overwhelmed with the resources he had to dedicate to all of their litigation. For them to stand here and suggest that they're in favor of limiting litigation, to me is offensive, knowing what I know.
How does that all bear on the legal issue?
Okay, we get to the fact that they're an employer. This is their business model, okay? I apologize.
That's all right.
I just want to know, how do you define your relationship with, the hospital's relationship with DCI?
Okay. We have an indemnity verdict against.
Now, what is
prior to that.
What is your relationship? What is the hospital's relationship? Do you contract DCI? You have no.
Absolutely, Your Honor. We have no contractual relationship with DCI.
Okay, then why are there doctors in your building?
We're a community hospital, okay? Very limited resources. Our biggest problem is staffing our hospital. It's what our executives do on a daily basis. They got to get doctors to come in. We couldn't afford to employ a full staff. So we have an open medical staff. When you have an open medical staff, there are federal regulations which require you to give a fair shot to anybody that qualifies. So when Dr. Nahata and Dr. Ganju show up as qualified nephrologists and make application to join our medical staff in furtherance of DCI's business, we're obligated to give it to them.
So if my mother were to go to your hospital and she dies while in the care of your hospital because she likes your hospital, you're not responsible. You're always going to say it's the doctors that are operating or working in your hospital.
Respectfully, Your Honor, I couldn't disagree with you more.
I'm asking you.
Okay, we accepted responsibility. We accepted our ostensible agency responsibility. The Washington Hospital is a stand-up member of a community, and they serve that community. And they accepted their ostensible agency responsibility. They stepped forward, they paid the McLaughlins, okay? That's the only way we can be here to seek indemnity. So we did. We have ostensible agency, and we're going to talk about that. Liability for this particular patient. A patient, the law of ostensible agency exists because we do not demand that patients understand the complicated nature of the modern healthcare system. Okay, it's a benefit to patients. It's an obligation that we've accepted, that every hospital, as represented by the Hospital Association, the amicus in this case, nobody has a problem with it. We know that when we open our doors, we're going to take on that ostensible agency responsibility. But we clearly understand the complicated nature of the modern healthcare system, as does DCI. They've carved out a niche, and they figured out a way to make a ton of money at it, okay? So once you get past satisfying the patient, as we did, it is now a proper function of the law of equity to allow those members of that complicated healthcare system to litigate who caused the loss. who pays for the loss? And that's what we're seeking to do. We have an established judgment against Doctors Nahata and Janju. It went to verdict before His Honor Judge Lucas, who did it. He dedicated so many hours to this case, and prior to trial, through trial. And one of the reasons I think we're here is because he wrote a 20-page opinion about his thoughts and his concerns in managing this now appropriate part of the litigation, which is the indemnification part. And in that 20-page opinion, he dedicated 10 pages to employer liability law and 10 pages to indemnity law. Nowhere has DCI ever addressed their liability as an employer. And that, I suggest to you, is what brings us here.
Well, good. Let's get to it. What's the liability? What's the tort liability of DCI that allows you, as a secondarily liable company, to seek indemnity?
Okay, if we take that in the purest of sense, we'll talk about it in terms of Washington Hospital is a passively liable entity.
Secondarily liable.
It's a passively liable entity. Secondarily liable, correct. Okay? DCI is an actively liable entity.
How?
They have employees carrying out the business of DCI. And I would like to take us back to Chief Justice Todd's opinion in the Camelback case, the Tyre versus Camelback. When employees, and this came up in the context of interpreting a release on a ski resort. When employees function, it is the company that's functioning. You can't distinguish those things. That is a matter of Pennsylvania Supreme Court precedent. It is a matter that Justice Todd has written about, quoting Travelers, which agrees. There's no distinction. Once you have employee producing negligent or liability producing conduct, that is a liability of the employer.
Primary?
It's not separable. You cannot sever it.
I think you can, because under that theory, your hospital had primary liability for the doctors.
I disagree. Employer liability is what DCI has. Ostensible agency liability is what I have.
Is ostensible agency, as is imposed by the MCARE Act, distinguishable from this concept of an employer being responsible for the torts of its employees?
I don't see any way how you can't distinguish the two. And I'm not asking for a free pass. The law provides means by which you can hold a hospital de facto employer of anybody. That is, you can go to a hospital and say, well, you had these policies in place, you did this, that, and the other thing. You are, in effect, the employer in this given circumstance.
Thompson versus Nason.
Thompson versus Nason. You have oversight responsibilities. Okay, those allegations were made by the McLaughlins against the hospital. They made de facto employer allegations against the hospital, corporate negligence allegations against the hospital. We have a verdict that says no. Washington Hospital is not the employer of these physicians. We have only a verdict that they are the ostensible agents of the hospital.
Why should they be bound by that verdict since they didn't participate in that trial?
I don't suggest that they are. I only suggest they be bound as an employer is. Okay. You cannot distinguish between liability of an employer and liability of an employee. It's the same. And I point the court to the builder supply case, the very case that DCI cites in support of their case. It is a very unique case. Builder supply is an auto accident that happened in Ohio. The primary case was litigated there. It came back to Beaver County because one of the drivers was from Beaver County. They were applying Ohio law where indemnity contribution is not permitted, so indemnity was more significant. But it had to do with a negligent party seeking indemnity from another negligent party. But in that case, they specifically discussed Philadelphia Company and Globe Indemnity. Those two cases are exactly what we have here. Passively liable entities getting indemnity from actively liable entities.
Didn't you stipulate that they weren't a joint tortfeasor?
We did not stipulate. The DCI refers to it as shifting sands. I think of this case as whack-a-mole.
Okay, where did you say they weren't a joint tortfeasor?
Assuming arguendo that they are actual employees, which they are, the court has now recognized they are. We don't need indemnity. We just need employer liability. We don't need contribution. We don't need indemnity. We don't need any finding. They are the employees carrying out the business of DCI. That's in Judge Lucas's opinion. He cannot deny it. He's saying, I don't know what to do here because they are the employer, and DCI and Nahata and Ganji were without question carrying out their business in the course and scope. That's why we're here. If there's one thing that we can walk away from, I think it's an agreement that ostensible agency is a mechanism to the benefit of patients walking into a complex modern healthcare system. That's it. It has no bearing upon responsibility. Or control. That's de facto liability. That's de facto employer liability. And there's a verdict in this case saying we did not control them. They're not bound by it, but they are liable as employers for these physicians. And we see indemnity cases between passively liable entities like the Washington Hospital who paid simply because they own the hospital. They didn't control, at the trial it was determined, they didn't control these physicians. They only owned the hospital where it is. In Philadelphia Company, similarly, somebody owned a pipe that then exploded. The Philadelphia Company paid the plaintiff, then they went back and got indemnity from the excavation company that damaged the pipe and caused the explosion. One passively liable entity, the Philadelphia Company, getting indemnification from a actively liable entity, the traction company, or it was an excavating company. Obviously, there were employees of the excavating company that broke the pipe, but you get indemnity from their employer.
So if I can make sure, this has been very helpful. If I understand what I'm taking from both sides here is, there's really no dispute over the law. There's a dispute over the facts. There's a dispute over, he's couching it in terms of an assumption that you both are vicariously liable. You're saying that's not true. So, but you agree with him that if you were both vicariously liable, you could not get indemnification.
And this brings us to Judge Lucas's.
Do you agree with that? If you were both, if all their liability was vicarious liability or secondary liability, you could not win on indemnification. Do you agree with that?
I don't agree.
You can get indemnification from a secondarily liable party?
An employer.
No, I'm giving you a fact. I know you want to dispute over whether an employer is secondarily liable or primarily liable. I'm asking you, the principle that they are relying on to win here is a general legal principle that a secondarily liable party cannot be liable in indemnity. Do you agree with that?
I agree with that in certain contexts. We're talking about indemnity, we're talking about fairness, okay? Fairness, in the context where that principle arises, is where we have a tortfeasor, okay? Someone that has caused a loss.
Right.
They cannot go back against their employer if they pay the loss. Let's say
you're adding facts. I don't want you to add facts. I'm just asking for the general principle. I know this may be difficult. You gotta understand. I'm new at this job. I'm trying to learn as I go. Okay. So just bear with me a little bit. The common law rule of indemnity, as I understand it, is generally where a secondarily liable party, meaning a party that didn't commit the tort but is liable for some other reason for the loss, can seek indemnity from the actual tortfeasor. Similar to how your hospital got indemnification from the doctors here, because that's a pretty standard thing. The hospital gets indemnity, the hospital pays, but they get indemnity. Maybe they recover, maybe they don't. But the doctors were the actual ones that committed the tort, correct?
Correct.
So, under the basic law of indemnity, you would agree that you cannot get indemnity from DCI unless DCI is actually liable in tort, not secondarily liable in tort.
I understand what you're saying, and there are cases that say that, and they are accurate. When you cause...
So the answer is yes.
Yes.
I know you've probably been told a long time ago never to agree with anything that a judge asks you on the bench, but I'm just trying to understand the law, because that seems to be the law that he's arguing.
Okay.
But he's presuming that his client is nothing more than secondarily liable in this case. Ergo, you can't get indemnification. Your argument is, oh, no. They're not secondarily liable. We believe they're primarily liable as an employer, and we get indemnity. That's where the dispute is. The dispute is not over... The dispute is not over the law. You two agree on the law. You're disputing the facts.
If you are an employer, an admitted employer, an established employer with an employment contract, when your employees commit a tort, you yourself commit the tort. That is the law of Camelback and Travelers that has to be set aside in order for DCI to prevail. You have to overturn decades of employer liability law in order to get them where they need to go. So, in fairness, when we talk about principles of fairness, there can be situations where an employee, can't cause a loss and then seek indemnity from their employer. You cause the loss, you can't go back against that employer. This is not that case. This is an passively liable entity and an actively liable entity. And the actively liable entity has an admitted contract.
I think you agree on the law. I think he agrees if DCI were actively liable, you might have a claim for indemnity, but he also wants to prove that you were actively liable. So it comes down to the facts. That's really what it comes down to.
Okay, but it's a unique posture. The posture is we had a trial. And people...
I'm not sure we have to sort all that out.
Okay, but I'm the plaintiff, okay? And I'm the plaintiff that has a $17 million judgment against 2 physicians and their employer, okay? I don't have anything else to prove. And this is where Judge Lucas needs direction. If you want to prove, if you want to share, because that liability belongs to Nahata, Ganju, and DCI, their employer. If you want to prove that liability belongs to me, first you have to give them the judgment, which I don't have anything left to prove. I have the judgment against these 2 employees. The only defense they have is that they were outside the course and scope of employment, which they don't assert. So it belongs to them. If they want to now file a complaint when we go back down and prove that I'm corporately negligent, that my nurses were negligent, that's on them. That's what the court needed direction on. My case, the Washington Hospital's case, has been established. The verdict was converted to a judgment. The judgment is recorded. It's not been contested. We're years out.
But under Justice Donohue's question, which I think you conceded to, is they are not bound by the verdict that you were not independently liable. And if you're seeking a common law indemnification claim, you are going to have to show that you are free from liability.
I have shown that.
Well, but you can't show it by a judgment that they weren't a party to.
I can't be burdened to prove that I'm not the factual employer.
No, that's a different issue.
But it's
Judge Lucas ordered a trial on 2 issues. one of which is the corporate negligence of your client, not ostensible agency, not respondeat superior, but corporate negligence. Something happened in the emergency room, if I'm recalling correctly, regarding procedures or something of that nature. DCI's contention that your hospital is directly on the hook for what happened in that context.
Okay.
You disagree that you could say, no, we aren't. Okay, but Judge Lucas ordered a trial on that issue, right?
He ordered a trial, and he said, I don't. He basically in the charging conference, we got to that point, and he said, I don't know how to conduct the trial. What are Mr. Chairs? What are you going to prove?
He entered an order in this case, did he not?
Yes.
There'd be 2 issues tried.
I don't know that he limited it to those 2, but those are 2 that he contemplated.
One was the direct liability of Washington Hospital. The other is who had the right to control the physicians, your client or DCI, and/or could be both. I don't quite understand that, but that's the second thing he ordered, correct?
Yes.
Okay.
But in the context of, like, look at Tonsick versus Wagner. Okay, you have a patient that alleged de facto control. You have a patient that alleged corporate negligence. You have a patient that alleged physician and nursing negligence. Okay, that's not here. Here, there's only DCI, and they don't have any claims. But as long as they get the liability for their employee, then they can file a complaint when we go back down. They can assert de facto liability. They can assert corporate negligence if they choose, and we shall defend. But I have no liability. That's been proven. That's what I come to this proceeding with. No liability and a judgment against their employees who are carrying out their business. And I suggest to you, the law, the Builder's Supply, Philadelphia Company, and Globe Indemnity, all cited favorably by this court, establish that I, as a passively liable entity, can get indemnity from the entity that caused the loss. Their employees, their excavators, their construction company, their employees caused the loss. I can get indemnity from them as the admitted employer of the liability producing parties.
Without any further litigation between DCI and its employees, the doctors, right? You're saying it's a given employer liability flows from the employee's action because here there was no allegation that they acted beyond the scope of their employment.
In Tonsick versus Wagner, which this court addressed, a very similar argument was made by the hospital. So the hospital came forward and said, this is at a time when we were working out from hospital immunity. So the hospital said, we have this captain of the ship doctrine where surgeons are liable for everything that happens in an operating suite, okay? So if surgeons are liable for everything that happened in an operating suite, and that clamp was left in the operating suite, only the surgeon can be responsible. And this court said, you're the admitted employer of these nurses, right? They had an obligation to look for the Kelly clamp, right? You're in. You have to answer because you're the admitted employer. So for DCI to get where they want to go, you have to overturn Tonsick, you have to overturn Builder's Supply, you have to overturn Philadelphia, you have
And as a matter of fact, they have to prove beyond the scope, which is not in this case, right? That the physicians were beyond the scope of their employment, which they were not.
They can't dispute it. There's 2 opinions from the trial court saying they're clearly, I have their employment contracts. This is their business model. This is what they do. That is the only defense they can pursue.
That was my point.
And it's gone.
Okay.
And I suggest to you that the employer liability law, the thing you didn't hear from DCI today, is what guides. As soon as we find out who the real employer is, what their business is, we define what ostensible agency is. It's a benefit for patients. It's not control by the hospital. Then everything falls into place. They take this judgment. Once we go back down, they can try and prove whatever they want to prove.
All right, anything else? Sure.
I had a case from the
Your Honor, great question. I can't, it's unbelievable to me. We were litigating this case for years with, emergency medicine, obstetrics, and it's not unlike a lot of cases that I've handled in my 25 years of litigating medical malpractice. It has never occurred to any lawyer I have ever dealt with to deny liability for their admitted employee who's carrying out their business. That's why we're here. Like they want to litigate endlessly their business model that caused a loss. They I have not had that, but that is litigated. It's litigated mostly in the truck driving context. Very often you'll have borrowed servants in that context. So there's multiple cases of people trying to parse out who's liable for what. Here, it's clear. Our only hook to these physicians is ostensible agency. And the only reason ostensible agency exists is to relieve patients of understanding the modern healthcare system. We are passively liable for these physicians. DCI is totally unlike, they're the admitted employers. They contracted with these people. That's what they do. It's how they make money. They should bear the liability of the loss.
Okay, I think we've got it. Thank you both, very well argued. And I'm going to, when this case is over, I'm going to submit it to the Board of Law Examiners for potential bar exam question.
Glad I passed the bar.
Commonwealth of Pennsylvania versus Ryan Michael Dunn. Representing Mr. Dunn, Ms. Stephanie Knoll. Representing the Commonwealth, Mr. Francesco Napa.
All right, good afternoon. Is Justice Doherty coming back? Yes, we'll just wait a minute or two, all right? All right. This is the case of Commonwealth versus Dunn. In this case, appellant was charged with aggravated indecent assault, statutory sexual assault, involuntary deviant sexual intercourse, corruption of minors, and endangering the welfare of a child with respect to allegations made with regard to his girlfriend's 13-year-old daughter. 2 days before trial, the prosecution sent appellant's counsel an email advising that it intended to call an expert at trial to testify pursuant to Section 5920 of Title 49 regarding the typical ways child sexual abuse victims disclose, react, and cope with such abuse. Attached to the email was a report summarizing the substance of the proposed testimony. Over appellant's objection, the trial court permitted the expert to testify, and appellant was convicted. We are asked to determine whether the trial court erred in permitting the expert testimony on short notice and whether the provided report was sufficient. please proceed.
Thank you, Your Honor. Good afternoon, and may it please the court. My name is Stephanie Knoll. I'm here on behalf of the appellant Ryan Dunn. Just a couple of tweaks,
Okay,
Your Honor,
all
with
right.
respect to the factual recitation of the case. You indicated that the notice that was provided to Mr. Dunn was a couple of days before trial, and technically that's true. I just want to make clear for the court that this notice was provided at about 4:30 in the afternoon, the evening preceding jury selection. So
Okay.
it was not as if there was, days, even though I would respectfully contend that that would have been insufficient to allow the defense to prepare.
All right, thank you for clarifying that.
I'm just not clear on one of the.
Oh, sure.
Pardon me, counsel. Were you picking on a Friday and trying on Monday? Is that what happened?
No, there was not a weekend in between. It was literally the next morning, the parties were proceeding to jury selection.
And then you were going to go right. Then did you go right to trial then?
The parties then did proceed directly to trial, yes. So there was not an opportunity really for defense to even digest what the minimal disclosure that had been given. It was probably a matter of hours before defense counsel filed a motion for the production of a supplemental report, indicating that the report that had been provided was insufficient to fairly apprise the defendant of what the substance of the expert's testimony would be.
And there was no case management order, and right, that's correct?
So there was a pretrial conference, a sex offender court conference, where the Commonwealth indicated that no additional discovery was forthcoming. That was
Sex offense court.
correct. Allegheny County Sex Offender Court.
Sex offense court.
Oh, I apologize. Sex offense court. There was a conference where the Commonwealth indicated to the defense that no additional discovery was forthcoming. That was months prior to the time that they actually disclosed this expert report.
So in the sex offense court, I know you never got a chance. We're on the procedure. The sex offense court, I unlike criminal division where there's the pretrial doesn't really do anything. The sex offense court, there is a sort of a case management order, but it doesn't roll out any deadlines for disclosures. Is that right?
That is right. That is right. And there was no case management order or pretrial order setting a schedule for motions or disclosures or anything like that. That's
and when
correct.
You went down to, before you went down to pick, you didn't try to get up there to see Judge Rangus and ask for a continuance?
Well, first off, I was not trial counsel, but yes, the record does reflect that in the morning after the defense attorney received this notice, again, it was provided at about 4:30 in the afternoon by email, that by the next morning, defense counsel had filed a motion seeking either the trial court to exclude the expert's testimony on the grounds that it was not disclosed in a timely manner, or the production of a supplemental report that had the appropriate level of detail to fairly apprise the defendant of
Not a continuance, but not a continuance.
well, he didn't, fairly enough, he did not use the word, I'm asking for a postponement, but I think it's implicit in the request for the preparation and the production of a supplemental expert report that would take time. That would certainly take time for the expert to prepare. But you're correct, Your Honor, he did not specifically ask for additional time to prepare.
You're saying that implicit in the request for additional time to do a responsive report
Yes.
is the idea that if granted, jury selection would be postponed.
Correct.
Okay, let's go back to the beginning and allow you to open your argument.
Okay, thank you, Your Honor. So I think that there are really two issues that are before the court here. First is whether a party that's seeking to introduce expert testimony concerning victim responses and behaviors must provide notice to the opposing party of its intent to do so. And second, whether that party must prepare and disclose a detailed expert report of the proposed testimony. Both lower courts in this case found that neither notice of the Commonwealth's intent to offer one of these experts nor a detailed expert report were required. And we believe that both lower courts got it wrong for several reasons. As this court held in Commonwealth versus Olivo, Section 5920 is a substantive statute that does nothing more than authorize the admission of expert testimony regarding victim responses and behaviors. Excuse me. Given that Section 5920 is a substantive statute, It doesn't usurp or modify the rules of criminal procedure that govern disclosures and the procedure by which expert testimony is presented. So we really believe that this case is governed by Rule 573 of the Rules of Criminal Procedure, which mandates that the Commonwealth disclose any expert opinions it intends to offer at trial. If an expert has not prepared a report, and we submit that the generic boilerplate vague letter that was provided to the defendant in this case is not an expert report. If the expert has not prepared such a report, trial courts have the discretion to order that the Commonwealth produce and disclose such a report. That report is supposed to state the subject matter of the expert's testimony, the substance of the facts to which the expert is expected to testify, and a summary of the expert's opinions and the grounds for each opinion.
Did you request that report, and did the court deny it?
Prior counsel, trial counsel in this case, did make a request the morning after he received notice of the Commonwealth's intent to offer this expert testimony for the production of an expert report, yes. The trial court denied that motion and ordered the parties to proceed to jury selection. According to the comment to Rule 573, a report is most certainly not required in every single case, but it may be necessary where the expert is, for example, unknown to the parties or testifying about something new. In this case, there was absolutely no inquiry made as to whether Mr. Dunn and his counsel were familiar with the expert at issue. Obviously, the Commonwealth was familiar with Ms. Messer, but Ms. Messer testified at trial that she had only testified a total of 8 times ever. Not all of those cases were in Allegheny County. So, and I would also add that, Section 5920 is and was, at the time that Mr. Dunn proceeded to trial, a relatively new statute. At the time that Mr. Dunn went to trial, there were only 6 published opinions that even mentioned this provision. And there was really no inquiry made by the trial court whatsoever as to whether this person was known to the parties or if the substance of her testimony was known to the parties.
Counsel, I want to challenge you on that. Wasn't it on the record that the judge indicated that he had testified numerous times, the expert had testified numerous times in her courtroom, such that...
Correct.
So, in essence, she did qualify him as an expert pursuant to 5920.
There's no issue here as to whether Ms. Messer would have qualified as an expert under Section 5920. There's also no question that Ms. Messer was familiar to the trial court.
And did defense counsel, trial counsel, request the court to cross-examine his credentials to challenge that finding of expert?
At trial, there was some brief questioning concerning voir dire, but if you're asking if defense counsel had an opportunity prior to jury selection, prior to the commencement of trial, to understand the qualifications, to challenge her qualifications, or to challenge the substance of her testimony, the answer is absolutely not.
And why not?
Because he was given notice the night before jury selection was to commence.
And when you were provided, before you went to, so why wasn't there a motion in limine, per se, to disqualify the expert report because you were precluded from having an opportunity to challenge the qualifications of the expert prior to the introduction of that report?
There was a motion filed the following morning. There were 2 motions filed the following morning. The first was to preclude the expert from testifying at all. The second motion was to have the expert prepare a supplemental report that actually provided notice of the substance of what her testimony would be. So those requests were made. There was no, to answer your question directly, there was no specific motion asking for voir dire prior to trial, if that's what you're asking.
I'm asking for challenging the qualifications of the potential expert for which they had surprise notice.
No, it was, I don't think that it's a question that Ms. Messer would and has since qualified as an expert under the statute. The question is whether or not the defendant was adequately prepared to meet that expert testimony given the lack of notice.
So the record looks almost as if there's an abuse of discretion standard should this come to the ultimate goal of against your client, I guess.
Well, the issues that are before this court are questions of law. I think that we need clarity from this court
I
about,
agree with you.
about what the law is before we can decide whether or not the trial court abuses its discretion in a situation like this. The issues that are before the court are whether failing to require the proponent of this evidence to provide the opposing party notice and to produce a report that adequately apprises the opposing party of what this expert is going to say, whether that conflicts with the rules of procedure, whether it conflicts with prior cases by this court, and whether it conflicts with due process, whether it's fundamentally unfair.
Well, the question I have for you is, when you look at 5920, are you indicating that that statute is ambiguous because it specifically indicates under qualifications in a criminal proceeding subject to this section, a witness may be qualified by the court as an expert. Therefore, she qualified him, and if qualified, may testify. So how do you invoke the qualification pursuant to the rules, what is it, 703? How does that play, or how should it be read in paramateria with the unambiguous requirements of this statute?
We take no issue with the court qualifying this particular person as an expert in this area. That's not something that we're raising in this appeal. It's not something that we're challenging in this appeal.
You're not, but I thought you were challenging the form, the paper that he provided with these nebulous commentaries. You're not challenging that?
That we are challenging, yes.
But isn't that the crux of his expert testimony? I'm just trying to understand where the defense is coming from.
So we are not lodging a challenge in the sense that we are saying that Jamie Messer, who is the expert that the Commonwealth called in this case, was not qualified to provide the expert opinions that she did provide. That is not the case. That's not the point of this appeal. I would be willing to concede for the sake of this argument that she was qualified to provide this kind of expert opinion.
Could I follow up on Justice Doherty's? So I think I see where he's going. Tell me if this is, as I read your briefing, I understood that at least two of the arguments are, and tell me if I'm wrong, that this ambush, so to speak, is a due process violation, so that putting aside the absence of a time requirement in any case management order, which not here, and putting aside the absence of any time requirement in the rule or the statute, that the 11th hour, the evening before, is a due process violation, number one. And number two, as I understood your briefing, the argument on Ms. Messer is that this is a boilerplate letter that could apply to any sex abuse case.
Yes.
It had nothing to do with this case.
Yes.
In fact, this case, the name of this case isn't even in that letter.
Right.
And therefore, it doesn't comply with 573B2 in the particular that requires, quote, the substance of the facts to which the expert is expected to testify,
Yes.
unquote. Because she gives opinions, boilerplate that they may be,
Right.
but there's no facts.
And
Correct.
before,
Am I wrong?
before you answer that, could I just supplement that question by saying, could you also address how she could have been more specific
Yes.
given that of this particular, against that, she had to be somewhat generalized. Now, whether she was too generalized, we can look at, but she could not have applied her opinions specifically to the facts of this case or the allegations of this victim without, risk of going over that line of speaking to the victim's credibility.
Well, Justice Wecht, I do agree that you are reading our briefing correctly, and those were the points that we are attempting to make. I respectfully disagree with Your Honor, Justice Todd, that
you were doing so well.
to the extent that who intimately familiarize themselves with the facts of the case. Take eyewitness identification experts, for example. They look at the police reports, they look at recordings, they look at all sorts of things to become extremely familiar with the facts of the case, and they're still able to render opinions about the reliability or the factors bearing on the reliability of the identification without commenting on the eyewitness's credibility.
I agree. But was it necessary when the sum and substance of her testimony was going to be what sex assault victims normally do, what they could be expected to do or not do in terms of reporting, in terms of reacting, these general propositions, she could not have tied those to this particular victim without violating.
Witness cannot say that this particular victim engaged in this particular behavior or this particular response, and those behaviors and responses are consistent with other similarly situated victims.
Right.
I agree with you about that. But she did do that without doing that, without being so connecting the dots. And I can draw your attention to various components of the expert's testimony where that did occur, because her testimony did touch on extremely case-specific themes that went beyond.
Without calling them such, without tying them to this case?
Right. She didn't implicate the accuser in this case in doing so, but obviously that's the connection that the Commonwealth wants the jury to make, right? And I think setting the scene a little bit would be helpful to kind of to flesh that out. So,
Again, here's another procedural question. But the issue that we granted was with regard to whether the decision is irreconcilable with 573, which is the discovery rule. Did your office specifically request any expert reports? I know you were Top Shot, but by citing the discovery rule, that discovery rule specifically says that the defense must request from the Commonwealth, and the Commonwealth must file within 10 days. It doesn't give the defense this be another challenge.
So, in full candor to the court, I don't see anywhere in the record a specific request prior to the time that the Commonwealth disclosed its intent to offer this expert the night before jury selection, where defense.
Experts are particularly used alcohol, yes?
It's a frequent occurrence, yes.
So the question I have for you is, why are you invoking 573 when a strict reading of the statute indicates that a defense must make a request before the Commonwealth violates the 10-day rule? I don't see how that's applied to this issue or your argument. So can you tell me why we should even consider
Sure.
that portion of your alcohol?
Sure. I mean, 573 states that it is mandatory discovery for the Commonwealth to disclose expert opinions. I guess the point that sex offense court conference on the record months before trial was set to commence, where the Commonwealth explicitly said, again, and this is in direct response to the court's questioning, there is no additional discovery forthcoming. So it would sort of be odd for a defense counsel to not take the prosecutor at his word or her word, I cannot remember which, when...
But that's opaque verbiage, because discovery, as you two know, is something a little bit different in common parlance than whether or not they're going to give you an expert report, right? Yeah, the discovery packet is a different matter than 573 expert report, right?
Well, it is mandatory discovery. Expert reports are mandatory discovery. The Commonwealth can't, I mean, and I think that the Commonwealth knew that, or else why would it be providing notice at all? Why not just show up to trial and introduce the expert's testimony?
Well, I mean, it's pretty clear, isn't it, in this record that your predecessor was blindsided?
Yes.
There was no, so that's, even putting aside whether this was a misleading statement about discovery back at the case management conference or not.
Because I think she had asked you about, and I think you were getting to the difference between what was in the expert report and what was testified to.
Yes, I'd be happy to do that. And I think before I do that, it's kind of helpful to set the scene.
If you do it before, you're going to risk getting off track again, and we're not going to answer that question.
Well, I appreciate being redirected.
In your defense, I don't think you ever really get to start your argument, but sometimes that's the way it goes.
Hey, I'm happy to answer the court's questions, of course. So, but I do think that this is an important part, so I appreciate being redirected back to this. You know, setting the scene just a little bit for what actually transpired at trial. Jamie Messer, who was the Commonwealth's expert, was the very first witness presented by the Commonwealth. The Commonwealth, in its direct examination of Jamie Messer, asked her extremely pointed questions regarding a number of behaviors and responses that were very, very specific to this case. And the answers to those questions sort of corresponded and directly foreshadowed aspects of the accuser's testimony. The perpetrator giving the accuser special gifts or presents, which the accuser may reciprocate.
That's textbook adult preying on child for sexual assault purposes behavior, though one would think that might be in every report about sexual offender behavior and sexual.
Well, but it's responding in kind. The accuser testified that Mr. Dunn would draw her pictures and write her notes, which she then reciprocated. It's directly kind of foreshadowing what the accuser's testimony. That's one example. Another example is that the accuser's disclosure may be delayed by a desire to maintain resources or financial stability, and this was a major, major theme in this case. The accuser testified that before, luxuries in life, when they moved in with Mr. Dunn, she had her own bedroom, big house with a pool, they could take vacations, there was a sauna, they could go out for fancy dinners. In other words, that the accuser enjoyed a quality of life after moving in, and her siblings and her mother enjoyed a quality of life that they never had before. So this testimony about the accuser's disclosure may be delayed because of a desire to maintain financial stability was a direct and important theme in this case, right? Because otherwise the jury would say, well, why didn't you come forward? Here's why. And it's the victim in this case, the accuser in this case, was 17. She wasn't an infant. She wasn't a child. She was
17 at the time of trial.
Correct.
She was 13 at the time of the first offense.
Correct. Too is that the accuser's disclosure may be delayed by a desire not to disrupt family dynamics, and that the accuser does not want the change in those family dynamics to be their fault. This was almost like a direct quote of testimony that was going to come from the accuser. If this is not a direct quote, it's very close. She said, "I didn't want to be the reason my family fell apart. I didn't want to be the reason that my step-siblings and my siblings weren't together." So these are
a response to those types of situations.
Exactly. And so the facts that they know about the case. So this idea that just because the expert is blind and doesn't have any personal information or firsthand information about the allegations is kind of irrelevant in my book, because the prosecutor definitely does. They know their case, they know what they're going to ask.
Can I ask one question? I don't know if I'm read. Does our review here, I get exactly what you're saying. I completely understand, I think, what the case is. I'm looking forward to hearing from the other side. Does harmless error enter the equation here at all in terms of looking at the evidence that was introduced, setting aside this and determining whether this was, let's assume it was, bad conduct on the part of the prosecutor or noncompliance or due process violation? Nonetheless, the evidence was overwhelming.
I don't know how the conviction could be desperately needed by the trial courts about the notice, both procedural in terms of how much notice is required by the Commonwealth or the defense. I mean, it's clear that the defense can call these types of experts, and to the extent that this court doesn't provide a clear ruling about what level of notice is required, I think two can and unfortunately will play this same game. I think that clear guidance is required from the court as to how much notice is required, whether that is a bright line number of days or whether that is a reasonable time period. that would allow a defendant or the Commonwealth to get its ducks in a row, so to speak. And then also clear guidance about how much information has to be included in an expert report so that the defendant, most of the time, the defendant will be able to prepare his or her trial strategy.
Okay, thank you very much.
Thank you.
Let's hear from the Commonwealth.
Good afternoon, Your Honors. Frank Neppa for the Allegheny County District Attorney's Office. If you'd allow me, I'd like to start by briefly talking about this idea of an ambush and gamesmanship on the part of the Commonwealth, because I don't think I addressed that sufficiently in my brief. Ms. Knoll, in her brief, on the very first page, in the very first sentence, said that the Commonwealth hid the ball. That was a direct quote. By keeping secret, another quote, its intention of calling an expert until right before the start of trial. But that's good rhetoric, I think. It's powerful rhetoric that the Commonwealth did something nefarious to try to unfairly harm the defendant. And in part, maybe that's why we're here, because that's such a effective use of language. But the record doesn't support that. The record, all we know from the record is that the expert's correspondence was dated, her report, if we want to call it that, was dated May 31st, 2019, which was a Friday. We do not know when that was received by the Commonwealth's attorney or in what form that was sent to the Commonwealth's attorney. We do not know when the Commonwealth's attorney came up with the idea of calling an expert. We do not know when she secured this particular expert.
Can I say, counsel, that whether nefarious or not, could be completely non-nefarious, could be ineptitude, sloppiness, overwhelming work on the prosecutor, the line prosecutor. For whatever reason, that doesn't change the fact that they got it the night before trial, right, and the line prosecutor says, "See you tomorrow at trial. And by the way, let me know if you now you want to take the offer." So let's assume good motives. Let's not assume bad motives. How does that change whether or not it is an ambush that raises any due process concerns?
The only reason I was making that point was because I wanted to make sure that this court was not basing whatever it's going to do on any sort of bad conduct by the prosecutor.
We did not have that understanding. I think I can speak for all of us.
Okay, and I would just add one thing to what, in addition to sloth or incompetence, or those are all negative things. Isn't it possible that the prosecutor, who said on the record that she has used this expert multiple times in the past, just did not think this was a controversial thing that this expert was going to be testifying to?
It seems a bit presumptuous for the Commonwealth to say it really can't be important for the defendant to know that we're bringing in an expert witness tomorrow, and furthermore, that the only thing you're going to give them is a boilerplate letter that could have been substituted in for 1,000 other sex abuse cases, because there's not one word in this case, in this opinion letter, about the facts of this case, not even the name of the defendant. So it seems, putting bad conduct aside for the moment, we're not here to talk about evil. We're here to talk about due process rights and any possible rule violation. How can you shrug that aside on these particular facts?
Well, I'm not sure that the court understands this or not. Maybe you all do, and forgive me. The expert didn't speak to the victim. The expert doesn't know anything about this case.
Commonwealth,
Yes.
the issue here is not the content, it's the notice.
Well, it's both.
I got it, but let's start with the beginning. 573. What is it, 2E, you're mandated by the rules of discovery to provide them with an expert report.
And we did.
And then you objected to a continuance. So why don't we assume, like you assume the defense would know that they're testifying, that you violated Rule of Professional Conduct 3.8 because you as a Minister of Justice did not carry out the specific obligation to accord with procedural justice? By agreeing that you are handing an expert report on the eve of trial, on the day of trial, jury selection, and agree to a continuance so that they can investigate.
Well,
Answer the question. Why would you object if this is about procedural fairness?
I can't speak specifically because I was not the person that was there. But I think it goes back to the content of this particular report. This, as I was trying to say earlier, this prosecutor said on the record that she had used this expert before who was just testifying to generalities.
No, I apologize. Did the defendant ever use this expert? Did this defendant ever know who this expert was? The credentials of the expert? The answer is unknown because the record's conspicuously absent. So the Commonwealth never put on the record. They got it that they knew who he was or she was, and the judge indicated she knew who he was. But the reality is the Constitution protects the defendant, and he didn't know who he was, or the record's conspicuously absent. So why don't you address how the defendant's due process rights were not violated by, and I will say it, being roughshod, handing a notice, and it makes it only worse if the district attorney knows all about it, so that it's an undue prosecution because you're withholding evidence that they don't know. I'm really startled by this conduct.
By the prosecutor?
Yes.
By the court?
No, I wouldn't say the court. The court knows this, and there's no rule that said the judge had to provide. There is a rule that says you have to provide your office. And due process protects Mr. Dunn from your actions. You're being the district attorney's office of Allegheny County.
But do you not think that what the content of the report has any bearing on this? You don't think that the judge's ruling was based on what was in the report? I don't think neither of the lower courts are saying that they're not saying it's okay to turn over an expert report 2 days prior to trial in all instances.
It's about due process. It's about notice.
In addition to that, if I could just add, I completely concur with Justice Dougherty. In addition, to answer your question that you put to us, it's also about the violation, apparent violation of 573B2, which the words I quoted earlier, the quote, the substance of the facts to which the expert is expected to testify. That's right in the rule. And again, as I said, looking at this boilerplate letter, which could have been introduced in 10,000 of these cases, there are no facts. So right there is an apparent facial violation of that requirement of the rule.
Are you saying that no facts, meaning an expert is required to speak to the victim? Is that what you're saying? Because
that was not the purpose.
What
of
facts
this,
are we talking
Just a minute. This was not the purpose of this expert testimony to equate anything to this victim, to this accuser. The purpose of this kind of expert testimony is to talk about victim behavior, which could go to any sex abuse case of a child, regardless of her name and the specific circumstances and the facts. So to me, it doesn't seem like the omission of facts in the report is a problem. Now, I guess I just threw you a softball.
Well, I don't think so either. I don't know what facts we are supposed to put in.
I'm only telling you that that's the rule. So maybe you think you're exempt from it, number one. And number two, putting that aside, you've still got your Jones problem, don't you?
Well, let me get back to that in a second. But what are you, again, are you saying there's a requirement that the expert needs to be
Counsel,
familiar with the
instead
case?
of asking Justice that question.
I'm
I
just
think
trying to
I
get-
think I think maybe your answer should be along what the Chief Justice was trying to feed you with it, which is, Your Honor, because this was a general expert opinion, there were no facts, and the rule only contemplates the conclusion of facts if facts bear on the testimony of the expert. Here, you did not believe there were facts that bore on the testimony of the expert, therefore you comply with the rule.
Thanks for the answer, Judge.
Yeah, thanks, I guess. But Justice Weck seems to be suggesting that that's not enough, and I'm trying to...
I don't think he was.
I'm trying to respond to that.
Presumably, there was argument by your opposing counsel in response to questions from the court with respect to hypothetical questions.
Mhm.
Presumably, some gloss on such hypotheticals would be within the ken of this language in our rule about the substance of the facts to which the expert is expected to testify. I'm not saying Ms. Messer had to go meet with this victim in this case or such, but presumably when we say in our rule the substance of the facts to which the expert is expected to testify, and not giving you the option, but rather saying you have to provide that, right? That the type of matters to be elicited the next day in response to hypotheticals would be colorably within that provision.
Go ahead and answer.
No? Yes.
No, go ahead and answer.
The question was that there should be more in there than what was in there. I mean, if you look at what she testified to, you can't have every word that a witness is that an expert witness is going to say at the trial.
That's why we have the word the substance of the facts.
And I would say,
Transcript of the facts.
I would maintain that if you read the report and you read her testimony, they're fairly comparable. If there's some sentence in the testimony that wasn't included in the report, I mean, that's a very difficult standard to hold.
Well, and it may be that if the Commonwealth or any party is offering a report by an expert who is going to testify as to general behaviors and not to this particular victim, maybe what should happen is there should be a statement in the expert report saying this witness will not address specific facts. This witness will not address this victim. Because this witness's purpose, now whether that was exploited at trial by the hypotheticals, I'll have to look at the record to see what I think about that. But this witness's purpose was to give a generalized statement about typical sex victim behavior.
Yes.
For example, in the report, there was no discussion about grooming, and that was a topic that your expert testified at trial. And don't you think that was unfair for defense counsel to attempt to counter any of that testimony in the absence of having the report that said that's what she was going to talk about?
Well, if it was unfair, I mean, that takes us to the prejudice.
We're going to get to that, but let's go back. Could you answer Justice Mundy's question?
Was it difficult for him to anticipate, defense counsel to anticipate that without having it written in the report? I guess so. I mean, what can I say to that? I guess.
Here's the other problem I have with your position, and again, we're going to get to harmless error, but you seem to take the position, the Commonwealth seems to take the position that because it's common for DAs to offer this kind of expert testimony, and indeed was common for this particular DA to offer that kind of testimony, and because it's common for this particular judge to have used this expert, that, you know, no harm, no foul. Everybody knows this is testimony in these kinds of cases. Well, a judge who tries these cases every day may know that, and a DA who prosecutes these cases every day may know that, but there is no expectation, in my mind, that a defendant who is in the system for the first time, you know, in a sex offender case, or his attorney would know this is just so common that you shouldn't be surprised by it, which I think was one of your assertions.
Well, I just know that the judge, who's very familiar with these cases seem to state that this is widely accepted
It's done
testimony.
all the time, but how would this attorney and this client know that? It's done all the time. Judge Arangos knows that. Your office knows that. But we're looking at what was potentially a due process violation to the defendant.
Counsel, can I just step back here for a minute, because it's no surprise to anybody that I never did criminal work. My work was in civil and administrative law. Never. What strikes me here is I'm trying to figure out, and maybe it doesn't matter, but I'm trying to figure out what was in the prosecutor's mind here. For one reason or another, don't know what it is, an expert that they always use in every sex offense case, that everybody knows this all happens, for some reason or another, they somehow just didn't get this letter until the Friday before jury selection. Again, I don't know how that could happen, but it did. You get it, you disclose it on the day before jury selection happens. And again, don't know why, don't know how, but you did it. But the defense lawyer goes in, and I'm kind of going back to Justice Doherty's question. The defense lawyer goes in and asks for a continuance, and it's just my experience that the lawyer who did this in good faith, as you have claimed, and let's presume there was good faith, would say something along the lines of, Judge, they should have a continuance. They're right. We gave this on the eve of trial, and it's only the fair thing to do. We'll postpone the jury selection, and we'll do it. What I'm struggling with is you're unwilling to at all give that up, to give up the idea that, you know what, maybe legally we're fine, but gosh, this was horrible. We shouldn't have done this.
Well, he didn't ask for a continuance. His motions were for the exclusion of the testimony entirely, or the filing of a more detailed report.
But see again, you're doing this, and again, I have to get used to this if this is the way criminal work works. I have to get used to this. But in civil work, this never would have happened. This never would have happened.
What's the this?
What happened here? That you drop an expert report the night before a civil trial, you go in, and all of a sudden, the trial happens. It just wouldn't happen. So your immediate reaction to my question was to blame the defendant and the defense counsel, when it seems to me that, putting aside that you're the prosecutor in the Commonwealth of Pennsylvania, sort of the right thing to do from a professional perspective would to say, Your Honor, we do need to address this. We just surprised them with this report the night before. We do need to address this. And I just don't, maybe it's not going to color how I resolve this case and how I vote on this. I need to understand why you're so unwilling to recognize something that seems so obvious to me, that this was just wrong.
Well, again, I wasn't there, but I'm stuck with what the trial court did.
No, you're not. I, with all due respect, I really don't like when lawyers come up and tell me that they weren't trial counsel. That thing, hold on. That bothers me a little bit. And all I'm asking you to do as a professional, as a licensed member of this bar, as a representative of the Commonwealth of Pennsylvania, to tell me that you think this was okay.
Well, you were asking me to explain somebody's motive, and I'm only...
No, I'm asking you to tell me whether you think that this was okay.
I think it had something to do with the content
If it happened
of
to
what was
you,
in
if
it.
it happened to you, would you be okay with it?
If I was the defendant?
No. If the defense counsel came up and dropped an expert report the night before jury trial was to begin, would you be okay with it?
It would depend on what it said. I think it would depend on what was in. If you look at the record in this case, defense counsel says he wasn't even challenging the report or the delayed reporting by the victim. It was only allowed in by the judge because she said, well, sometimes these jurors aren't clear on whether or not, they're not clear on how a victim behaves. They might ask, why didn't she report this immediately? So she said the Commonwealth was allowed to put this expert on. The defense didn't even have a particular problem with it. He says on the record, it's not part of my defense to even talk about how late her reporting was. So in that sense, it's not that, at least the parties there did not think it was that big of a deal. And I think that's part of how we got here.
Let me follow up Justice Brobson's question. Are you telling this court that if the defense had given you an expert report the night before trial, you would have not objected? Is that what you're telling this court?
I mean, in most situations, I probably would have, but there are probably some instances where I'm thinking, well, this is not something I'm even going to try to combat.
Let me ask you
so
this.
what?
Let me ask you this. Since you going over and over in your brief the text messages, and that's fine, and telling us that evidence is so overwhelming, why would the Commonwealth so err? Why would it even go here? They had an open and shut case, you're telling us, with these text messages. Why would you create this potentially reversible error by giving them an expert report on a boilerplate expert report on the eve of trial?
I guess because it wasn't viewed as particularly significant, something that the defense was going to try to combat, and they haven't, and they didn't. They never said in the immediate aftermath or the long time aftermath, oh, you know what, I should have, if only I had this much earlier, I would have countered this way, and I would have countered that way, and I would have countered. That's never happened.
Well, they objected. That's all they had to do to protect the issue. I mean, there's no waiver here, right?
But I was just answering your question that you posed as to why this would unfold in the manner that it did, and I think that is why, because it wasn't viewed by the parties as particularly controversial.
Counsel, can I just interject? The only objection they had to make was the one that they made, which is we want an expert report. I mean, I'm looking at this two-page letter.
Mm-hmm.
I mean, this could have existed a year and a half before this trial, for all I know, because there's nothing about this case. This is not an expert report. And I mean, one of the reasons we're here is to determine whether or not there must be an expert report. And I would suggest to you, unless the person who submitted this letter takes a stand and reads the 6 or 7 bullet points, then you need an expert report. I mean, this expert at trial was presented with factual scenarios. The minute that happens, you're triggering the requirement that you provide a statement of the facts relied on and the opinions derived therefrom. And so the only real objection they had when they got this was, wait a minute, we need an expert report. That's what they asked for. I don't know what else they had to do under those circumstances to say, this isn't fair. This isn't fair. And you could have avoided the whole thing by putting the witness on the stand and say, I'm handing you a letter dated May 31st, 2019. It contains 3, 5, 6, 7, 8 bullet points. I'd like you to read them to the jury. That's not what you did. You tied these concepts to factual issues in the case. And the minute you do that, that requires an expert report. And I'm just going to suggest to you, from someone who tried a few lawsuits in her day as an attorney, I mean, if you tried to do what I just suggested, I would object to the relevance of it. Because unless you can tie what an expert is talking about to something that is before the jury, it's irrelevant testimony. So this whole discussion we're having now just sort of, it eludes me in the context of relevancy of testimony, fair notice of what the testimony is going to be, with expert opinions, fair notice about what the facts that have been considered. I'm not talking about anybody having to interview a witness. I'm sure there were witness statements. I'm sure there were police reports. I'm sure there were documents that could have been reviewed. But, I mean, I just don't know what purpose this serves unless in some context it's tied to the case being tried. And the minute you do that, you're triggering the expert opinion rule.
But you said there's nothing about this case in that letter.
There isn't.
She didn't review the case, and there's no rule that.
See, but you're making that sound as though that makes sense to anybody in the context of when you call a witness to testify. You are calling a witness to testify to help enlighten the jury about what victims do in certain circumstances. The certain circumstances of this case were the predicate for the hypothetical questions that were asked of this witness. I don't know how you could divorce that from the concept of what experts do at trial.
Do you want to say anything to Justice Donahue before we move on? Because I'd like to move on to harmless error.
It seems like I'm just continuing to dig a hole for myself, so I guess I'll move on to.
Before you move on to the Chief Justice's area, could I ask something that was touched upon?
Absolutely.
Reading this letter, which I concur with Justice Donahue, it's unlike any expert report I've ever seen.
It's not an expert report.
Well, that's
their
right.
objection.
That's right. The other question I have about it for you is, hasn't the DA's office informed experts in this area that it hopes to use of our decision already 2 years old in Jones, where we said, quote, Dunkel remains valid insofar as it precludes expert testimony concerning victim responses and behaviors that touch upon witness credibility, unquote. That seems to me that although this 2-page document doesn't do much, that's one thing it does seem to do.
It touches on witness credibility?
Yes. Do you want to comment on that?
I don't see how it does that. So I can't
Victim
comment.
responses and behaviors that touch upon witness credibility. Children who disclose abuse often do not disclose right away, and the disclosure, et cetera, et cetera.
But we have never precluded this kind of testimony. I mean, this kind of generalized testimony. The particular circumstances of this case are troubling, but as a general rule, we've never said that a witness cannot testify about general victim.
I think Jones allows it.
Exactly.
I think it allows it.
So you feel this 2-page document is not a violation of Jones, putting aside all the other problematic aspects?
I don't think it's a violation of Jones, no. I don't. I do not.
Okay, Mr. Nepple, we're going to move on to harmless error because I think you can sense there's a little bit of a negative reaction to
seems like it.
the first argument.
It took me about 20 minutes to figure that out.
Yeah, yeah. Did you offer to come today, or were you always planning to?
Yeah, Mr. McCarthy.
McCarthy's over there.
McCarthy sent him a note last night. Just kidding.
All right. Well, here's perhaps a question in a little bit more friendly territory for you. Given if everything that the court has indicated is some indication of what a reaction is to that first issue, let's talk then about what happens to this verdict. Was it harmless error given the other testimony or the other evidence in some respects? This was a he said, she said case. But then we have those text messages from the defendant, which I guess someone could try to argue means something other than what they say, but I don't know. No more counting down until you're 18, no more being uncomfortable. They're going to put out a warrant for my arrest. It's not your fault, it's mine. I never meant to hurt you in any of the ways I have.
I still love you.
I didn't
and
know
want to
what
be
you
with
see as abuse was abuse. I still love you and want to be with you. This is a 38-year-old man talking to a 15, 16-year-old girl. I'm sorry, I don't know what else to do. I abused you and I thought it was love. I don't know why I still feel what I feel for you. I'm very sorry. I barely recognized that you were too young. I believed in destiny and fate. I was wrong. I mean, these, one could conclude, are very powerful pieces of evidence that this defendant knew exactly what he was doing and, in fact, acknowledges his guilt of at least some of these charges. So if you could comment on that and whether or not this case could be viewed in terms of harmless error, I'd appreciate it.
Well, yeah, I agree with you, and that's why I said in my brief that this prior discussion that we were having was purely academic, because I don't think it's the harmless error standard which puts the burden on the Commonwealth. It's prejudice, which the defendant has to establish, and I don't know how he can do that given, one, all those text messages. It's not a he said, she said, as Ms. Knoll tries to portray it in her brief, because she ignores those text messages when she does that. And I don't see how there's any sort of reasonable interpretation of those, other than
she doesn't ignore them, though. I guess she's saying they sound bad, but the explanation for them was he was just trying to save the family, not that it was about the victim and him. So she's not totally ignoring them, but go ahead and analyze
his defense counsel asked him one question about the text messages during the trial, asked him specifically about the one that says, "I still love you and want to be with you." And his answer was that it meant he only wanted to be with her in the family dynamic. Now, that's just preposterous. I mean, that is ridiculous. That's a ridiculous answer. And to suggest that these things mean anything other than he had sexual relations with this girl, as she testified to, it's an absurd notion.
What other evidence are you relying on for your lack of prejudice argument besides the text messages, the victim's testimony?
The victim's testimony, in conjunction with these text messages prove that the defendant is lying, because he said nothing happened at all. He said there was if he had said, well, I kissed her, I did. He denied everything, and this proves that testimony was a lie and indirectly establishes the truth of the victim.
Any other evidence besides? I mean, we look at prejudice in terms of overwhelming evidence of guilt. Anything besides the victim testimony and the text messages that you want to direct us to?
No, but I do have another argument involving prejudice, irrespective of the text messages, which is that, again, I touched on this earlier, the defendant has never, prior to this, not in the trial court where he needed to do it, said what he would have done in response to this testimony from the expert if he had it earlier than he had it.
Well, didn't they file a motion to preclude?
He filed a motion to preclude.
Yeah, the defendant had no burden here. You had the burden as the Commonwealth, and the point is, what they would have preferred was the expert not testify.
But there's no grounds for the expert not testifying. There's no grounds for saying that testimony is inadmissible. The trial court had the discretion.
I'm responding to your point. They don't say what they would have done. My point is, what they would have done is to have your expert not testify.
But there was no basis to have that testimony excluded.
Could I just stop you there? You are wandering right back into the territory that we just left, which is really dangerous territory for you. It's not good for you. So could you just come back and get into the prejudice arena again and tell me if there's anything else we've missed?
I was trying to answer that question, and
maybe you were lured into that area, but I'd like
lured him. I didn't.
I'd like to bring him back.
Isn't luring still a criminal offense?
Is that in this report?
Just if you could wrap up by telling us, is there anything else that you'd like to offer by way of evidence or by way of argument on the prejudice issue?
I think I've done enough here.
Let me ask you, shouldn't this be a teachable moment for the Commonwealth when it has a very strong case with what would appear to be consciousness of guilt evidence, that it shouldn't that there ought to at least be a supervisor involved in checking that there's not these last-minute report dumps the night before trial?
I could pass that on.
And just one more question, and that's this. Can
can you comment on why you make a prejudice argument as opposed to a harmless error argument? Is it because you have the burden of proving that beyond a reasonable doubt?
I think the harmless error burden is on us, but the cases say when there has been an improper admission of expert testimony, the defendant still bears the burden of proving that he suffered prejudice. So that's why I'm talking about prejudice as opposed to harmless error.
All right, any other questions? Very well argued
Thank
by
you.
both. Thank you very much.
Hope you both feel like you had a workout.